All right, Jesus Suarez Marino. Good morning. Thank you for dressing appropriately for court. All right, on this case, today is your plea deadline date. So have you all reached an agreement or do you want a jury trial?
We have not reached an agreement. We need a jury trial.
All right, and I'll need to make sure that you all have your acknowledgement of discovery. All right, so your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you have to plead open to the court. Do you understand?
Yes, ma'am.
All right. How long do y'all expect this case to last?
Say 3 days. Tops.
All right, Ms. Ferguson, I need a jury trial date, 3 days.
Okay, February 10th.
All right, that will be your jury trial date. Counsel, is there any motions that need to be heard?
Not today, though.
All right, just have a seat. Once you sign the reset form, you'll be excused.
Thank you, Judge.
You're welcome. And counsel, if you'll make sure you sign the acknowledgement of discovery before you leave.
Sorry.
All right, and state, is this alleged to have been a adult or not adult? An adult?
Adult victim, yes, Your Honor.
All right. And counsel, I was just asking because I wanted to make sure there were no CPS records or anything. All right, thank you. All right, William Gordon.
Yes, we're that's my case.
Yes. All right.
So we reached an agreement, but it's a to-do offer. So we'd like to see if we can do the plea the week after next. It's going to be straight time, no application.
All right, Ms. Ferguson. If you can reset this for December 1st for disposition.
Let's see if I can get you a copy of it. Thank you.
All right, thank you. And counsel, before you leave, so that we'll already have it, if you can make sure an acknowledgement of discovery is
Will do.
completed. Court is calling 2025 CR 010818, State versus Julian James Montez Jr. Can I have parties announce?
Bob Brabach for Montez.
And are you Mr. Montez? Counsel, have you received all discovery? Did you review it with your client?
Yes, ma'am, I did.
Court will find that the state is in compliance with discovery. Mr. Montez, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney?
Yes, sir.
Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, ma'am, we do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Montez, did you review court's admonishments with your attorney?
Yes, sir.
Did you understand it and sign it in all the appropriate places? You're charged by indictment with possession of a controlled substance, penalty group 1 gram to 4 grams. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to present you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, he's mentally competent.
I'm sorry, if I could have that trial court certification back. Mr. Montez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Oh, Your Honor.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, sir.
If you're not a U.S. citizen, by entering this plea, You will be deported, denied naturalization, and re-entry into the country. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at a cap of 6 years in the prison. There's $1,000 fine, and the state is silent on your application. Did you understand that to be the plea?
Yes, sir.
Defense,
Yes, ma'am.
state? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, sir.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
No, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor, seat offer seats, exhibit 1 and all. attached.
No objection, Your Honor.
Did you review the waiver and stipulations with your attorney? State you may be excused. Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Counsel, if you want to request a PSI and TAP evaluation, it will take approximately 8 to 12 weeks because there's a backlog.
Yes.
And, or if you want, he can be brought back sooner, probably in about 2 weeks, and you can bring whatever evidence you want the court to consider.
We can come back in 2 weeks.
All right, and you're waiving PSI?
No, I think we want a PSI. I think
All right, so then that's 8 to 12 weeks.
we'll do the PSI.
All right, I need a date for PSI and TAP.
January 8th.
All right, we'll see you back on January 8th. At that time, I'll make a decision on your application based upon whatever evidence is presented to the court. All right, thank
Thank you,
you.
Judge.
Have a seat, sir.
All right, and Rick, are you all handling both cases?
And Hunter Morris is here on the other one.
All right.
Oh, I'm sorry.
Hunter?
No, I'm sorry. No, I'm sorry. Wrong.
Oh, wrong-
That's
wrong
my-
person.
Never mind, Hunter.
All
CTD is handling the felon possession.
right, but Hunter, we still appreciate you. All right, so today is a plea deadline date.
And we're gonna reject that. We'd like a trial sentence.
All right. So how long do y'all expect this trial to last?
I'd say so.
I'm sorry,
3 days.
3 days. I need a jury trial date, 3 days, and counsel, if you'll make sure you do an acknowledgement of discovery,
Yes, ma'am.
February 10th.
February 10th.
No, I'm putting this down. I'll get you out of here in a second. I'll meet you then. Oh, okay. It's the next one.
All right, thank you for dressing appropriately for court. Once you sign the reset form, you'll be excused. All right, Edward Lopez. So on this case, do you have all the discovery?
No, Your Honor, and we've made an appointment for 1:30 on Monday to review a video that the nature of the video is such that we can only view it in the DA's office.
And
And
that's the only discovery?
I believe so, Your Honor. What I want the court to understand is that it could be dispositive on the video when we view it. I don't want to say too much.
Mhm.
But I think you understand what we're talking about. And if we need to try the case, we're probably going to request some CPS records.
No, the CPS record should have already been turned over
Okay,
because that was, you all, or either the court mentioned CPS records in September. So you should already have CPS records.
Okay, I'll check with Mario, my co-counsel on that, Your Honor. You could be correct.
Hmm.
So, but we're gonna, on Monday at 1:30, we're gonna review the video.
All right, Ms. Ferguson,
Yes, ma'am.
set this for the second week. Y'all will need to confer off docket. Set this for a second week in December for a plea deadline date.
December 11th.
All right.
And we will get an email on that, Your Honor.
Oh, however, he's gonna have to sign a reset form.
Okay, thank you.
All right, thank you. All right, on Mr. Westbrook.
Judge, pretrial January 6th, jury selection January 12th.
Okay. On jury trial, you say January 12th?
Yes, ma'am.
All right, on Ryan Westbrook, I need a jury trial date and a plea deadline date in February.
Yes, ma'am. I can do February 17th.
All right, state on Westbrook, you all need to have him bitch warrant if he's completed his matters in federal custody. All right, thank you.
Thank you, Judge.
Thank you.
Thank you.
Jose Angel Caceres. So how are you doing today?
They're not for.
Okay. All right. So on this case, where are we on discovery?
Your Honor, it looks like we are missing quite a bit. I'm not sure that I need to get it completely. I think we have it. I just need to get it. But it is a surveillance video and it is phone extraction and multiple computer extractions.
All right. And then is there any CPS records?
Yes, Your Honor.
Any school records?
Your Honor, in this case, there are 6 different victims. So I don't have any school records at the moment. Defense has not requested.
Are you going to be requesting school records?
Your Honor, I don't know because I haven't gotten the discovery to start off with.
School
got-
records?
Mhm.
So if there's school records, is there any type of therapy records? Just make sure they're available.
Your Honor, one other thing
Mhm.
is any type of sensitive case like this, I always have my client watch the forensic interview with me.
Mhm.
And we want to arrange a time and maybe during the holidays, it may be a good with that when you don't have a jury that Mr. Casares can be brought over, but in the jury room to allow us to watch it or
Yep.
stay in the courtroom if the courtroom is clear.
You'd have to make an arrangement with the deputy, so speak to them about the scheduling issues, because they will be in charge of security. And if
Mhm.
you all will both get a date from them.
Your Honor, one thing that came up is the state wants to be present during the time that my client and I watched the video. I've
Why?
never had anybody, the state present. I've had the deputy present. Oh, no, it's okay.
Whenever this process yesterday was a different case, and that was absolutely that came up. So like I told the defense counsel, I don't mind asking it whatever way. I'm totally fine with that.
Okay, great.
Mhm.
Yeah, and if we can do it, yeah, but yeah, the holiday may be a good time because it's a little without a jury.
Okay.
So we can get that
All
scheduled,
right.
Your
But
Honor.
what I can tell everybody is if there is an issue with her and her client being allowed to view it alone, and when I say view alone, the deputies will have to be here because he's in custody. But if there's another issue, we can have a hearing on it. And what I can tell everybody, I don't think that it is appropriate for the prosecution to be present when a defense attorney is reviewing evidence with their client, unless the defense attorney has no objections to it, because maybe they want to discuss issues. Now, because your client is in custody, the deputies will be present because they're in charge of security.
Mhm.
Yes, Your Honor, and I
Yes.
think that was more to, if we couldn't get a jury room and had to do it upstairs in our conference room. So we just need to work out logistics.
Mhm.
All right, thank you. Ms. Ferguson, I need to reset for discovery. If you can set this in late January.
Seems like a good day.
All right, thank you. And then if you'll discuss with the deputies a date to have him brought over to view videos.
Thank you, Your Honor.
You're welcome. Nicholas, carry on. Good morning.
This is the individual who's in federal custody.
All right, so what are the federal dates?
He's already been sentenced. He's in federal prison. His
Okay.
mother's here. She informed me that she thinks he's gonna land in Fort Worth. I told the prosecutors that. They've, I guess, been working on trying to get him.
All right, so is this going to be a jury trial? Okay,
I couldn't tell you. I
how
don't,
long do y'all expect the trial to last?
just simple, 3 days.
All right,
Yeah.
Ms. Ferguson,
Yes.
and if I could see the state on, carry on. All right, Norma, on this case, if you could set it for a jury trial date and a plea deadline date, December.
We did try to get him here from the Fed, and they told us that it's gonna be another 6 to 8 weeks until they can release him.
Hasn't he already been sentenced?
He's in transit from whatever holding facility he was at to his like final resting place for prison, like the facility he's going to be housed at, and they said that they can't release him to us until he gets there. So we were told it's gonna be another 6 to 8 weeks. until-
We'll see. All right, Ms. Ferguson, set it for December.
Number 9.
All right, council,
Sure,
December 9th.
thank you. Judge, I
Thank
have
you.
another individual who is on bond.
Just 1 second. I have to put this in the system. Joseph Rodriguez.
Oh, here's the discovery acknowledgement.
Thank you. Look, you are anticipating. I appreciate that.
Judge, the state has made us an offer and we're not declining it. My client has a job in which he's working 6 and 7 days a week. We're sort of contemplating things. I also opened up their file today.
Okay, I'm sorry, I cannot hear.
Oh, I'm sorry. And then I also opened up the state's file today and there's several disclosures about officers being under investigation. So I need to look into those sorts of things too.
All right, state. Disclosures concerning officers.
I'm sorry, on Joseph Rodriguez, there are a number of disclosures in that. I was on the judge, I want to look into what this was.
Okay.
So make sure they're available for him.
The disclosures are in the file. If you think you need something more than what's in there, then he'll just let us know. We'll work on it.
All right, Norma, set this for a plea deadline date in December. This will be your final plea deadline date. The court will not extend plea deadline date further. Norma, if you'll just put it on December 9th as well.
Okay.
All right, is there anything else? Do you have any questions?
No, ma'am.
All right, thank you. Just have a seat. Once you sign the reset form, you're excused.
Thank you.
You're welcome. Imani Robinson,
Morning, Judge.
good morning.
I'm present on her, Judge. It's a motion to set bond. We reach an agreement.
All right. Could you give me the bond information? All right, it has lead attorney as,
I just filed a notice. This was accepted this morning.
okay.
I e-filed it yesterday, but it was accepted this morning.
All right, is she coming forward?
She's in custody, Judge.
Oh, she needs to be brought out.
Okay.
Is she
Imani
here?
Robinson?
Jonathan Dreamer? All right, and this appears to be criminal trial division and also family violence. There's a new case.
Pick.
Oh, it's Pick.
Yes.
Hi.
So Judge, just the backstory. So I've been coming to court repeatedly on the family violence case. There's been a case with Pick, or a couple cases with Pick that have been kind of percolating. And then he was indicted, I guess, on how many counts?
I'm gonna get out my
Okay.
multiple, Judge. 8 counts, Judge.
All right, and is that on the kidnapping?
Yes.
Okay.
So I've been appointed to those cases now. I don't have any discovery on them. So obviously, I think the discussion all along was those are going to be the cases we were going to try. I'm bit taken aback by the 8 different counts, a little, I think, overreached by the previous prosecutor, but nevertheless, I'd ask for a discovery deadline so I can try to get the discovery on those new cases and figure out what I'm doing with them. And then on a side note, he tells me when he was magistrated on the new cases, no bonds were set.
Mhm.
So, which I found kind of unusual, but I don't know who did the magistration, but I'd ask the court to set bonds on those cases. I don't see why he wasn't given a bond when he was magistrated.
All right, and this is on the newly indicted case?
Yes.
Yes, Judge, with the sport, with. You have to report.
All right, do y'all want to proceed with an oral motion to
Yeah,
set
I
bond?
would, Judge.
And State, are you prepared to proceed?
I think this would be enough, Judge.
All right, thank you.
Yes,
And what I can tell you is on the 2024 CR 0924 case, which is the assault family household. Let me see. Okay, he has a bond on that one.
He was out on bond when all with these new cases finally got indicted.
Okay. All right, the court is calling 2025 CR 013272, State versus Jonathan Dreamer. Can I have parties announced for the record for the state? For the defense?
Robert Mauer.
And are you Mr. Dreamer? All right, defense, are you requesting a bond?
I am, Judge. I'm requesting the court set bonds on the cases that he was magistrated on, but no bonds were set.
All right. Any objection to the defense having an oral motion to set bond?
None, Judge, but the state would like to proffer a report from this court's review.
All right, just one moment. Any witnesses?
No, Judge. I mean, I can tell you, look,
I'll
for
need,
purposes of the bond hearing, I guess I can call Jonathan Dreamer.
all right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
They need to speak louder.
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Jonathan Dreamer.
All right, defense, you may proceed.
Jonathan, I know you've been incarcerated
Just one
since,
second, I'm sorry. Everyone, please whisper, we're on the record. You may proceed.
you've been in custody since you were picked up on these new charges, correct?
Yes, sir.
Do you, I guess, once you were arrested, you lost your job, is that correct?
Yes, sir.
Do you have any family who can help you make bond if you're given one by the judge?
Yes, my my niece and my sister.
Okay. And do you know how much money they have set aside or can get for bonds?
They don't make much, but I know they could at least get like 1,000.
Okay. And do you have bail bondsman you can work with that you might be able to work payment plans with?
Cowboy bill.
Okay. All right. I have nothing further to.
All right, state, any questions?
Mr. Dreamer, were you on bond in the family case when we picked up these cases? Or did these have to prior to the family case?
Judge, I'm gonna object to any. I mean, if the court wants to review the records, I don't want my client talking about dates, but I think, well, the court's aware and there's judicial record that my client was out on bond. These cases were filed at large when we were coming to court, and then he got picked up once they got indicted.
All right, so here's the court's question.
Yes.
The case that he is indicted on that he doesn't have a bond for,
Yes, Judge.
what is the alleged offense date?
November 8th. That might be a stenographic. error.
Yeah, that's an error.
So November 8th of 2023.
All right, and then the case that he previously had bond for, you're saying the assault family violence case, what's the alleged offense date on that case? All right, state, you may proceed.
No additional questions.
All right, I have a few questions, and it's questions that are related to bond. First, in defense, if you know the answer to this, you can answer it, or your client can answer it. Has there been any type of mental health diagnosis in the past, or any type of mental health medication that has been previously prescribed to your client?
There's nothing that I'm aware of. Did you have any sort of previous
sir.
psychiatric?
No.
And there was, I know they do mental health evaluations at the jail, but I didn't receive any red flags
Okay,
on that at all.
and then my other question in the past, has there been any type of drug use?
Not that I'm aware of.
No.
All right, any other questions?
None from the stage.
All right, any other witnesses?
No, Judge.
State, any witnesses or evidence for the court to review?
Yes, Judge. Judge, at this time, I would offer states one issue just for the purposes of this court's review and steering.
I have no objections.
Okay. States exhibits 1 and 2 are admitted for purposes of this hearing. And the court will review. All right, the court has reviewed states exhibits 1 and attachments. Any other evidence?
No other evidence, Judge.
All right. Defense, what amount? I'll just figure out what amount you're asking for and then I'll hear argument.
Well, Judge, I can tell you, I was a bit taken aback by the sheer amount of charges that were filed because I think the previous discussions didn't quite encompass all of those. I mean, obviously there's a bond schedule in place, but I'd ask the court to look to the low end just based upon the sheer number of counts that were filed. I think a lot of those are probably going to go away. I'd ask the court to set bonds on each charge at 25,000. I think it'll be hard for them to make it, but it still gives them an opportunity. I don't think there was GPS in place before, but that might be appropriate in this circumstance if the court is concerned about safety to the community.
State,
Judge, is this court setting bond by case number or by county?
case number.
Case number?
Yes.
Yes, the cumulative bond on this case be 150, with full GPS if released.
Well, if it's all in one case, then I'd ask the bond be set at 100.
All right. And I'm saying all in one case because it makes it easier for the clerks.
Sure.
And so this is under cause number 2025 CR 01327. And what I can tell you, Mr. Dreamer, according to new case law, you're not entitled to bond, but I haven't received the evidence on the previous allegation of the assault family violence to make a decision to deny you bond. But this is what the court will do. There's to be no contact with the complainant. There's to be full GPS, waive fees, and the court will set your bond at $200,000. And I need a date for discovery on this case, please. And counsel, I know the previous discovery date on this case was today, but you've been in jury trial.
Yes, ma'am.
All right, so if we could do a discovery date for that last week in December.
I'll be here.
All right, so your discovery is going to be December 18th. And if someone, I'm going to give you all a blank form. If on the blank form, if you could write down the court's ruling with regards to the bond motion so that the clerks may have it. All right, could you grab that from the printer, please? And counsel, if your client can just sign that acknowledging that he's on notice,
Yes, ma'am.
and if all parties will sign that. All right, yes, thank you.
Yes,
Is there anything else?
No, Judge.
Any questions, Mr. Dreamer? Any questions? All right, thank you.
Thank you, Judge.
You're welcome.
Yeah.
All right, then let's go back on the record. State's exhibits 1 and attachments were offered for review. It's my understanding from state and defense that it was not to be admitted into evidence. So state's exhibits 1 and 2 are withdrawn. Thank you.
Thank you, Judge.
Amani Robinson, before she comes up, counsel, is this a motion to revoke?
It is.
Have you all conferred on the motion?
I haven't, Judge. I just got retained on her last night. So I got here to get a motion to set the bond for her.
All right, could I see the motion to revoke?
I should have it, Judge, because Ms. Abrams had sent me a copy.
On, Ms. Robinson's case.
Mhm.
We are not ready to proceed on the motion to revoke.
Okay, oh no, we're just doing the bond.
Okay, I just wanted to let.
Sure, no problem. And council, I wanted to see the motion to revoke to see if there's any need for no contact orders.
I don't believe so, Judge, but I don't wanna,
Well, I mean, based upon the
Yeah.
number one that's in there,
what's number one?
assault.
Okay,
I don't know why this isn't pulling up. 008-663. I'm gonna try to look this up by name because Odyssey is not pulling her up. All righty, Imani Robinson.
and I conferred with the state this morning, Judge, and we did reach an agreed amount. If the court
All right.
honors that amount.
Date. Imani Robinson, the court is calling 2024 CR 008-663. State versus Imani Robinson. Could I have parties announced for the record?
David Andre Woodard for Imani.
And are you Miss Robinson?
Yes, ma'am.
All right, defense, you're here requesting a bond, is that correct?
Correct, Judge.
All right, and defense, what bond amount are you requesting, or is there an agreement? I'm sorry? All right, Miss Abrams,
Yes.
and state you may be excused. On this case, she's currently on probation. Is there any conditions that need to be added as far as any no contact orders, any mental health or drug issues that need to be addressed with the bond? Twenty 2024 CR 008-663. All right, thank you. Has your client, since I've last seen her, has there been any type of mental health issues, any mental health diagnosis?
Not to my knowledge, Judge.
Okay,
No, Judge, she doesn't wish to speak.
all right. There's going to be, the court will follow your agreed order. There's a $7,000 bond, full GPS waive fees. There's to be no contact with the complainant. And the court's order is to be entered on November 21st state. And the reason why it's November 21st is because the complainant needs to be notified that she'll be released. If you're able to contact the complainant today, then it can be entered into the system today. All right. And then Miss Ferguson, if you can set this, counsel, do you have all of the discovery?
I don't, Judge.
All right. Norma, if you can set this for the first week in December. All right, it'll be set for December 4th. And probation, that's for them to obtain the discovery. All right, is there anything else?
No, Your Honor, thank you.
Right, and if you'll check with the state and come back to me on whether or not the order should be placed in the system today or tomorrow.
Okay, thanks, Judge.
All right, thank you. Patrick Ballantyne,
Good morning, Judge.
good morning. Who do you have?
I have Luis De Leon. It's a motion to set bond on a MTR. He is in custody.
All right, have you conferred with the state?
I conferred with the state on, I believe it was Tuesday. We had an agreed recommendation for the bond, but I know that you like to hear testimony concerning any
Yes.
special conditions, so that's why we came back today.
All right, thank you. Deputy Laura, is Luis De Leon out here?
Sorry, Luis De Leon,
Yes, can you have him brought out?
he's downstairs, Judge.
All right, they'll bring your client out in a moment, Mr. Ballantyne. Once he's brought out, we'll take up your matter.
Thank you, Judge.
You're welcome. Huston Sewell, All right, so I'm assuming the sanity issue was addressed
It was, Judge.
Yes.
and the results were same? All right, and you have all discovery?
While we were waiting for the evaluation, I did go through the biopsy. We were missing, I think it turns out we were missing DNA and serology labs from Texas DPS crime laboratory, so I did put a note on those things. So this moment, I do believe it would be at least 60 days.
Okay, so the court has a hard time understanding with the nature of the case, why anybody didn't think there should be DNA.
I think so, Judge. The easiest thing would be just to order it excluded and then we could.
All right, this is going to be set for jury trial and the plea deadline date at the same time. How long do y'all expect this trial?
Mark is at least 4 or 5 days, 6 days.
All right, Norma, I need a jury trial date, 4 to 5 days. And this needs to be set no later than February.
The courts indicated that if we're at trial and those results aren't back, that obviously they would be admissible.
Oh, I mean, I'll hear
Okay, all right.
Yes. and make my ruling.
You do the February 10th.
All right, February 10th is going to be your jury trial date. What I can tell you, counsel, I don't understand. We've been on this case since March, and it shouldn't take a year to obtain DNA evidence.
I agree. Judge.
Otherwise, something shouldn't be indicted. Yeah. It's like, don't indict it. All right, so we're going to be back for a jury trial date and a plea deadline date on February 10th, 2026. So everybody be expected to go. Ms. Sinwell, you'll be brought over dressed for trial. You'll be dressed in whatever clothing whatever civilian clothing you have at the jail. If you wish to be attired in something differently for trial, you'll need to do a clothing exchange. Counsel, my understanding, the jail has changed that. So you need to have her clothing exchange done within 72 hours of trial.
You mean before, 70 hours before trial? Judge? Okay.
Yes. All right, thank you.
Thank you, Your Honor.
You're welcome.
Have a seat, ma'am.
I have one more, Judge. I think it's on the same.
All right, who is,
On page 8, Judge, just one down, Danny Reader.
Have a seat.
all right, have a seat. Danny Rivas.
Then will.
All right. So what is happening with this case?
Judge, an offer was made today, conveyed today. My client would like a little bit of time to consider that offer.
All right, Norma, set this for the first week in December. That will be your plea deadline date. The court will not extend it any further. All right, we'll see you back on December 2nd.
Thank you, Your Honor. Appreciate it.
All right, thank you. Once you sign the reset form, you excuse, and if you could make sure I have the acknowledgement of discovery.
I will, Judge. Thank you.
All right, thank you. Daryl Payne. Good morning. So he's in a state of crisis. My understanding, there are some misdemeanor cases.
It's just informed by probation, but I've had, as you know, I can only contact Don.
Yes.
They had tried to get him to go to appointments. We were scheduled a couple of times, and unfortunately, now he's in custody, so I will set a bail visit, but I wasn't sure if you wanted me to approach on this status, so.
Well, on this case, based upon the information that you all have given me, there's probably going to have to be a competency evaluation, which I anticipate he's going to be determined to be incompetent. And then we're going to have to wait for that to resolve itself. So this is probably going to have to be set in the new year. And if counsel, if you discover something in December, that means he's competent and ready to proceed. Just let the court know, we'll make that happen. But there's nothing I can do.
I understand, Your Honor. I just, since he was on the docket, I wanted to.
No, I appreciate it. And I regret that there is not a hospital or any of that, because he probably needs long-term care to address the mental health issues. So we'll set it in late January. I need a late January date. All right, and it will just be for status council.
And Your Honor, I'll
Mhm.
move them, and of course, I will file the competency as soon as I have them. If
Okay.
it's good.
All right, and could you reach out maybe to his brother and let him know?
Of course.
And I don't know if that's an appropriate placement anymore. Not that the brother's doing anything wrong, but I don't think he's equipped to make sure he takes his medication and all of that. All right, thank you. James Edward Sanchez. Hello. All right, today's plea deadline date.
Judge, there's additional discovery that we need. There's evidently some CPS records out of New Mexico. So state said that they would subpoena to get those. But we need a little more time.
Yes, previously we have the CPS records from Texas, and we have disclosed those over to defense. Defense pointed out that we had records today. So I went ahead and sent you a request for those to be approved.
All right, Ms. Ferguson. I need a jury trial date and a plea deadline date. Put this in February.
Yes, ma'am. Let's do February 24th, Judge.
All right, February 24th, you'll either reach an agreement or either you will be in jury trial.
Thank you, Judge.
Once you sign the reset form, you are excused. Thank you. Philip Perez. Hello, Mr. Perez. I'm doing okay. How are you doing? All right, what is the update on the mental health evaluation?
Judge, may I comment on that?
Yes.
I just reached out to Lori because I had done the application online for the assistance from the MAC and they didn't respond. So I finally spoke with Lori, maybe a few days ago. And I filed a motion for the mental evaluation and they're gonna get back with me on that. I'm not sure how long that process will take. But
All
he's
right,
gonna-
Norma, can you call the magistrate's court, ask them if they received the evaluation? Because the court has already signed it.
But we had kind of discussed that strategy going forward either way, Judge. I just filed a motion to be absolutely certain that's done.
Okay,
I apologize for not being here on Monday.
no problem.
No one's answering.
All right, set this for January.
Let's do January 12th.
All right, they should have information on your competency evaluation at that time. Thank you. Do you have any questions about anything? All right, thank you.
Thank you, Judge.
You're welcome. All right, State Engaged, Gara, have you had a chance to review the defense's request for bond?
Yes, sir.
Are y'all ready to proceed? All right, court is calling 2025 CR 008. I'm sorry, 2025 CR 006868, 2025 CR 006869, 2025 CR 006870. State versus Gage Gara. Could I have parties announced?
State.
Trey Maurer from Mr. Ghetto.
And are you Mr. Gara?
Yes, ma'am.
All right, defense is requesting a bond be set in each of these cause numbers. Does he not currently have a bond, counsel?
Your Honor, his bond, he's currently remanded without bond. I believe through my conversation with Lauren that we have come to an agreement to reinstate the current bonds.
Well, I see here that he was remanded without bond based upon a violation report. Does anybody know what the violation
Your
report
Honor,
is concerning?
I believe it was that he FTA'd on a misdemeanor out of County Court 9. And then I believe that, and then you issued a judge's warrant based on that FTA, I believe is the timeline of events.
All right, could I have a copy of the violation report, please, if anyone has it? Counsel, if you would give us a moment while I pull that up.
Okay.
Because I want to make sure the ruling I make is an appropriate one. Just
good.
give us a moment.
Yes, would you like my
Oh.
client to sit down?
Yes, and let me give that to you.
Thank you.
I need the order that I ruled upon.
that what you were looking for?
Yes, thank you. All right, I'm sorry about that, Mr. Guerra. I know he has crutches. If he wants to remain there, he can remain there. All right, we're back on the record. So state, in regards to this case, you're asking that the previous bonds be the same amount be reinstated?
Yes, Judge, on the phone, I would ask, or this week, defense counsel and I agreed on releasing a $12,000 bonds because the athlete from, and that one was already dealt with.
Okay. And how was it resolved?
That one's still showing pending as well as these felonies, and it looks like it is, the misdemeanor is next set on 12/4 for the arraignment, so I can just send a global after.
And Your Honor, I'm not sure what's going on with the misdemeanor. The attorney record he had on these felonies is also the attorney record on the misdemeanor. That attorney withdrew on all felonies. I'm not sure if he intended to withdraw on the misdemeanor as well, but he still shows the attorney record on that case.
And I'm assuming he's on ignition interlock?
Your Honor, again, I'm not the attorney of record on that case, but I can pull it up and see right now.
Okay.
I don't see the ignition interlock ordered on this case, Your Honor. Not that I can see.
All right. In each cause number, the court is going to set the bonds at $12,000. The court is going to order outpatient treatment, waive the fees. And that's outpatient treatment for substance abuse. And there will be ignition interlock on all accessible vehicles. All right, and let me see what date we're gonna come back on.
I have a 12/4 date, Your Honor. There's a final discovery in here.
All right, well, we'll keep it at 12/4.
Thank you, Judge.
All right, is there anything else?
Your Honor, just for clarification, did the court reinstate the existing bond or did they just reset it at the 12,000?
I'm resetting at $12,000. If you call the bondsman and the bondsman wishes the bond to reinstate it, then the court will order it as a reinstatement.
Okay,
All right, is there anything else?
nothing from defense, Judge.
All right, and counsel, if you have that information for the bondsman later today, just let the clerks know.
I know the bondsman was also his attorney, so I do not anticipate them wanting to go back on.
All right, thank you.
Thank you, Judge. Maybe excused. Or I have
Yeah.
another one, but I'm need to speak with.
All right, thank you. All right, Audrey Bash. All right,
On this case, we're still waiting for a PSI interview to occur. In the meantime, Ms. Bash has taken additional classes, and this gives her additional time to take a few more classes, and she's currently enrolled. There's a verification letter that she's doing more substance abuse classes.
all right.
And we-
So on this case, does anybody want to see if the court can get an expedited PSI?
That would be great, Judge.
All right, so just give me a moment and I'm going to see if I can get this. It would have to be at the beginning of December.
That would hopefully mean that they're back here before Christmas.
Yes.
That's the goal.
All right, so let me make a phone call and then we'll see if we can get that done.
Yes, Judge. You want Ms. Bash to have a seat?
Yes. After December 4th.
Yes, Judge.
All right, what date?
Yes.
Is December 12th okay? All right, Ms. Bash, we'll have you back on December 12th. All right, I'm sorry that there was a communication mix-up, but we'll have it done by then. All right, thank you. December 12th. Are you all ready on DeLeon? All right, Mr. DeLeon, if you'll come down. All right, does anybody have a copy of the motion to revoke?
I do, Judge, but it's full of notes.
Okay, let me see. I can pull it up in the email. Ms. Abrams sent it. It's just, sometimes it's easier seeing the paper.
I wouldn't want to expose this court to the prejudicial notes that I have here.
Oh, let's not do that. And Mr. DeLeon, I'll be reviewing the motion to revoke. not to decide whether or not things are true, but just to make a decision on if I were to grant your motion for a bond, that the conditions I set are appropriate. Okay. All right, while they're printing it out, the court is calling 2024 CR 3774 State versus Luis De Leon. Could I have parties announced for the record for the state? Defense? For the defense?
Patrick Ballantyne for Mr. De Leon.
And are you Mr. De Leon?
Yes, ma'am.
State, any objections to the defense appearing by Zoom?
Judge.
And Mr. De Leon, do you have any objection to your counsel appearing by Zoom?
No, ma'am.
All right, you are here. Oh, thank you.
Well,
You're here requesting that a bond be set. Is that correct, defense?
That is correct, Your Honor.
All right, and it's the court's understanding that you all have reached an agreement?
We have.
Judge, but perhaps not to conditions.
All right. Any witnesses with regards to conditions for the court to set?
Yes, Your Honor, we would call Mr. De Leon.
All right, Mr. De Leon, if you could raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Louis De Leon.
All right, defense, you may proceed.
So, Mr. De Leon, the court is presently considering whether to grant you a bond on this motion to revoke, what that bond should be set at, but she also needs to know if there's any special conditions that need to be imposed as a condition of your bond. I'm going to ask you about a couple things in particular. First, I want to start with any history of mental illness that you might have. Do you have, or have you had in the past, a diagnosis for any mental illness or disease?
No, sir.
Are you receiving or have you received in the past any treatment or therapy for mental health issues?
No, sir.
Okay, I want to ask you also about substance and alcohol issues that you might have. Have you ever received any treatment or counseling, whether court-ordered or voluntary, for any substance abuse or alcohol abuse issues?
No, sir.
Okay. You're under oath, and can you affirm to this court that you do not have an issue with substance or alcohol abuse?
No issue, sir.
Are there any
Alright.
other I'm sorry, are there any other special conditions that you're aware of that this court might need to impose as a condition of your bond?
No, sir.
Okay, thank you, Judge. I'll pass the witness.
Any questions?
And if I may just talk about procedurally, the new case, Judge, not the substance of the new case.
Yes, can you tell me the name of the complainant?
In the new case, Judge,
Yes.
it is Ms. Natalia Aguilar.
All right.
Mr. De Leon, did you get picked up in a bond set August of 25 this year from the new assault case?
Yeah. Yes.
You get arrested in
Yes.
August?
Yes.
They set a bond.
Yes.
And then was that bond forfeited?
I'm not sure, honestly. I believe last I heard it was like 4,000.
Did you get rearrested in that case?
It's in August.
Yes.
I turned myself in for the MTR.
You turned yourself in for the MTR.
Yes.
Were you aware that there was a failure to appear in September?
No. When I talked to my probation officer, it was August 27th, I believe, and she said that she was gonna, I guess, I don't know what it's called, but essentially she was gonna, so that there was no violation, she was gonna essentially, I don't know, waive it or something like that. And then once I turned myself in, everything would sort itself out.
Or they set that bond again, September the 4th?
I'm not sure, sir.
No additional questions, Judge.
All right. So do you all anticipate this being a contested hearing?
Unsure.
Well, Your Honor, I guess you've looked at the MTR at this point. There's a new number one that would be contested. The number two allegation, I need to confer with my client, but I don't know that would be as contestable. So I am.
All right.
That's
Ms.
the best
Ferguson?
I can tell the court today.
All right, this is going to be set for a contested hearing. Ms. Abrams, are you able to have, if there's a need for an officer, are you able to have that officer here? We can put it on December, either December 9th or December 16th. All
Judge,
right,
w- oh,
yes.
okay. Is December 11th available? Because I have some other cases in your court that day.
All right, let me see. Ms. Abrams, is December 11th?
Yes, I.
All right, December 11th. And Yaya, could you do a reset form for contested hearing? So your contested hearing is going to be December 11th. You need to be here. If you're not released, you will be brought over from the jail. So the court is going to follow your agreement. Bond is going to be set at $50,000. There's to be no contact with the complainant and the alleged new number one. And state, do you believe you'll be able to contact the complainant to let them know he's received bond today?
Yes, Judge. Cool.
All right,
Is this the complaint on the new number one judge or the complainant on the underlying offense?
both.
We'll let them both know. And for the court, we were discussing several times.
Oh, the defense wrote on here that, that was the original bond amount, correct?
The original was 50,000. That's correct.
That's what was written on. I thought that was the agreement. So do y'all have an agreement or no?
I think we did, Judge, accept that.
All right, then the court will follow your agreement. The court will set your bond at $75,000. As I said before, there's to be no contact with the complainant and the allegation of the new number one. And of course, there's continued no contact with the complainant for the instant case. Do you understand? All right. So parties, if this is going to be contested, you all need to be prepared for a contested hearing on December 11th.
Yes, ma'am. Judge, the state further was asked for GPS, but that part was not.
All right. Mr. Valentine, the state is asking for GPS. You're opposed?
We oppose that, Your Honor. We don't believe it's a necessary condition in this case.
All right. And state, what is the reason for your request of GPS?
The underlying offense, Judge, for which he was placed on probation earlier this year, fled to indecent assault, and was bled down. So he's only been on supervision for 6 months, 5 months, 6 months before he's rearrested for this new offense, which is another violent offense on the state. He is a danger now.
All right. And defense?
I'm having a little trouble hearing Mr. Morris, but I believe the concerns he's expressed would not justify anything like full house arrest. I don't think that GPS is necessary. This is not an instance of some sort of assault or improper contact with the victim in the case before the court. So, Your Honor, we would either ask that GPS not be imposed and that issue be left to the misdemeanor court's discretion handling the new number one, or if the court does see fit to impose GPS, it be tracking only with to monitor any contact that he might have with the two no contact subjects in the case.
All right. This is what the court will do. There's a $75,000 bond, which is agreed to by both parties. There's to be no contact with the complainant in the instant case or in the allegation of the new number one. There's to be partial GPS, waive fees, and that is for attorney consultations. Is there anything else?
I think from the state judge.
So,
Judge, may I ask that that partial be extended to any employment provided proof of employment is provided to the tracking provider? Or
once there is employment that has been obtained, then the court will consider that at that time.
Thank you, Judge.
All right. So what that means is you're allowed to go speak with your attorneys. That is it. So if you drive to your attorney's office and you see an HEB and you're like, I should stop at the HEB. You're not allowed to do that. You must leave from wherever you're stationed with your GPS. If it's at your home and you have an appointment with your attorneys, Pretrial Services is going to want to know of that appointment. And then you are to leave there without making stops to meet with your attorneys. Do you understand? Is there anything that you do not understand about the court's orders? All right, so you'll be back on December 11th. That will be for a contested hearing. Both parties will be prepared to proceed at that day. All right, is there anything else from the state or the defense?
Nothing from the defense. Thank you, Judge.
All right, thank you. All right, you're excused. Robert Porter. Who do you have? All right, is this a motion to revoke?
It is, and we're ready.
Okay. All right, the court is calling Isaiah Johnson or Asai Johnson. Could our parties announce for the record? Could I have a file stamp for a motion to revoke, please?
Ready to go forward.
Okay.
And Mr. Porter?
Oh, it's not.
Okay, then we have to set it for contested.
All right, this is going to be contested.
It is. I'm ready for my contestant right now.
Okay. All right, so we're setting this for a contested hearing. All right, Mr. Johnson, your contested hearing will be set in December. All right. Is there going to be any objections to witnesses appearing by Zoom?
Yes.
All right.
Your Honor, we bring, leave, probation officer from Florida to testify to a single allegation, so we'll have to see if we can accommodate.
Okay. All right. If you all confer on well, let's do this. On this case, Ms. Ferguson, if you recall it for the first week in December, and at that time states you'll need to be able to tell the court when you'll be ready for a contested hearing and making arrangements for the person in Florida to be here.
Yes.
All right, we'll see you back on December 4th. All right, thank you.
Thank you, Judge. I'm ready on my other one, too, Judge.
I'm sorry.
I'm ready on my other one.
Bring him up. Who is it?
Avelino Lopez. This is the one, Judge, that we pledged, you gave them deferred, but you set it for a restitution hearing and also wanted to see what the results of the probation is recommending Saturday.
All right, and who's your client? What's your client's name?
Avelino Lopez.
Could I have the file on Avelina Lopez, please? All right, Ms. Abrams, on this case, is there a top recommendation?
Judge, so for him, his top recommendation is for him to go to safety. The original conditions indicate for him to go to safety if not accepted into felony drug court.
Mhm.
As we are aware, felony drug court is not accepting any new clients at this time. So I did get the safety documents, everything signed this morning.
All right, so you will be going to SafeP. All right, do you have any questions about anything? Please take advantage of that program and internalize it. And when you're released from SafeP, make sure you follow through because a lot of people tend to drop off and not go to aftercare, but you'll need to do that, you understand? And if there's anything that you need and you feel as though probation is not addressing it, once you're released, you can come back to the court. You understand? Thank you. And there's a restitution issue?
Yes, Judge, you said it for restitution.
Yes.
We did receive an itemized bill on the university, but without getting into what the bill will be. Our complainant has been using residential treatment as well, so we are unable to communicate with him. We're communicating with the Mexican, which is his sister. She did inform us that she believes that he had on Medicaid, but for some reason, the hospital bill is not paid. So we're still trying to gain clarity on that, of whether hospital bills are going to be covered by Medicaid, and then if not, I think we need to get them connected. We're trying to get them compensation so that the bill can be reduced if states need to ask for a different.
All right, so what we can do, Mr. Porter, after he's completed SafeP, if there's no objection, we can address the restitution issues.
There is an objection because we're set for restitution hearing today. You don't have any witnesses to go forward, then there should be no restitution. But if that's what the court wants to do, I
Yeah.
understand.
All right, and then state, of course, if you have the items before he's released from safety. And if the state and the defense, if you all can reach an agreement, then we can take care of that and have your client by Zoom.
Okay, thank you.
All right, Ms. Ferguson, if you'll put this, we're just gonna put it in February because everyone should have some information by that point. So we'll put it in late February for restitution hearing. Darren Villarreal.
She's present, counsel. Nothing further.
All right, where are we on discovery?
Judge, we should have discovery. There's a misdemeanor out of the same incident. I've gotten discovery through that. I know that I've gotten an offer from the state. We've discussed the case. I'm sorry, I have not gotten an offer because we've discussed the case. The state needs to look at the video before they can make an offer. So we're asking for some time to get that done.
All right, Ms. Ferguson, if you'll set this in the second week of December and state at that time you need to be prepared to tender an offer.
Yes.
Thank you, Your Honor.
Yes. All right, once you sign the reset form, you're excused. Eric Simmons. Eric Simmons going once. Eric Simmons.
Eric, come on up.
Hello. I'm doing great. How are you doing? All right, today is plea deadline date. Have you all reached an agreement or is this going to be a jury trial?
So here's the deal, Judge. There were some CPS records that I just received the disc today. There was also an issue with some body cam that they say has been uploaded to e-discovery. I didn't get them when I downloaded everything, but they say they're uploaded, so they have made an offer. We're not willing to accept that right now. But if we could just reset for the plea bargain deadline, see what happens with that new discovery.
All right, this will be your final plea deadline date. Ms. Ferguson, set this for the last week in December, please, that we're here. All right, that will be your final plea deadline date. Counsel, you'll need to provide them with a thumb drive, maybe.
Oh, no, I've got the, for the body cam.
Yes.
Yes, Judge.
All right, once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
Thank you, Judge.
Matthew Maher. All right, today is plea deadline date.
Yes, Judge, we have a plea date on a misdemeanor that will dispose of this case of January 7th in order for him to finish.
Okay, why was that like January 7th? Because we were here in October, and then there was a plea deadline date for November 3rd. Then there was the misdemeanor case that you all were supposed to work out. And then today is the day for.
I understand, Judge. We've worked out the misdemeanor case. There's some classes that are as a part of that deal that I was unaware of when I talked to you. I understand that we need to set it for trial. And I'm just asking, my request would be we set it on the day that we're supposed to plea, because I anticipate it being resolved, but we're at the
When is
pleasure of the
that?
court, January 7th.
All right, Norma, recall this for January 8th. And that's going to be, well, just one moment, not January 8th, Ms. Ferguson. Do it for January 12th, and that's your jury trial date and plea deadline date. If things are taken care of before then come back.
We'll come back and hopefully we'll be here on the 7th to let you know.
All right, thank you.
May we be excused if we get that?
Yes,
Thank you.
you're welcome. All right, Jose Escalante. Have you conferred with the state?
I have, Judge. It's really just a clarification of a previous order you already entered, Judge.
Good afternoon, Your Honor.
Good afternoon. So he's asking for contact with his minor children and the motion. Is there going to be any objection?
Did you previously granted that? The problem is in the order you gave him permission to have supervised contact with his children, which we're not objecting to that.
Mhm.
But you also ordered that he cannot have any overnight stays with children. So GPS is interpreting that to mean even if he's supervised, the kids can't sleep in the house with him. So him and the family are having to sleep in separate quarters.
All right. It's going to have to be supervised. All right. Is there anything else?
That's all we have on the Judge.
All right. Thank you. All right. You too. And if you'll bring up your other client. All right, and you're David Solomon, join us. All right, there's a motion to modify bond conditions. Is there an agreement or no?
This is a case we just finished, I believe, last week, down to, get the date view on the 14th. Down to Naka's court where we did one. And Judge Nakata ordered partial GPS, a bond of 50,000, no contact order with complainant, and no possession of firearms.
Okay, all right. Court is calling 2023 CR 2677, State versus David Duenas. Could I have parties announced?
Raymond Martinez, Mr. Duenas.
And are you Mr. Duenas? All right, defense has filed a motion to modify bond restrictions off record. State is stated they're opposed to tracking only. All right. And you're stating that Judge Nahara did order partial GPS for employment or no?
Yes, for employment,
So counsel, what is the issue with partial for employment?
Judge, problem is that Mr. Duenas sells cars, and as you know, car salesmen are constantly on the go, test driving, moving cars, et cetera. And so with partial, he's allowed to go to the dealership, but he can't leave and actually do his job. So, and in the past, when he's been on GPS, he's been allowed to do tracking for the same reason. He's been in the car business for a long time. The second issue, Judge, is he needs to travel outside of Fair County, sometimes to deliver cars to other dealerships in other cities and or bring them back. And so we're asking for a travel permit within the state of Texas.
and the state would object based on the charge, the underlying charge, Your Honor, this defendant did shoot at somebody. I believe, and you can correct me if I'm wrong, but it was his ex-girlfriend's new boyfriend that he was shot at, and then on this case, he picked up in his case for choking, Your Honor. And so we believe that this defendant is closer to and we will bet on that basis.
All right, any further argument, counsel?
Judge, I mean, the underlying MTR, Judge, that was a trial case before a jury, and that's already been resolved. On the MTR, we're set for contestant in December. He's gonna have a whole month out of work if he doesn't get these modifications.
Okay, all right. The motion to alter the main conditions is denied. Is there anything else? All right, thank you. All right, so has the sealed family violence case been taken care of?
It has not, Judge, Ms. Jones was looking, yeah.
Ashley Jones for the state. Your Honor, I did look into the case. It has not been assigned an intake prosecutor yet. It was just filed with our office, I believe, in September of 2025. And so it's going through the process of getting a file jacket and getting uploaded to our system. I do not have enough information on that case to concur with defense on that.
All right, so when are you going to have information?
Your Honor, I put in a request for several, for police reports so that I could get more information. And then I put in an email to our file officers so I could see when it is was finished.
All right, counsel, will you be here the second week of December?
I will, Judge.
All right, Ms. Ferguson, set this for the second week of December. And that will be for discovery. And if you don't have the information, you all will need to present on the record the reasons why that information is not available for defense, who has it, and they'll need to come down to explain why the defense doesn't have it. What date? All right, we'll be back on December 11th.
Thank you.
Thank
Judge.
you. Israel Gonzalez. Why were you late for court?
I went to the one downstairs at Essen. When I knew.
All right, so here's the thing. What court did you have downstairs? Which court?
Forgot that I got a new judge.
Okay.
I went to the wrong one.
All right, so now you know where it is. You should have already known where it was because you've been here before. So do not make that mistake again, all right? All right. State, were you able to tender an offer in this case? It's Israel Gonzalez. And I believe this is going to be family violence as well.
He just got indicted on another case, Your Honor, which has just been handed the indictment.
Okay. And is that through family violence?
Yes.
Family
Well,
violence.
Yeah.
You have Israel Gonzalez. Do you, with regards to that case, are there CPS records?
You'll give me just one moment.
Sure. I'm just waiting for information.
Okay, Judge. I have three clients. All right. Then I have 8 in Atascosa waiting for me.
Gonzalez's case, I did not personally confer with that sponsor, but I can review it and make an offer if that's.
Well, he has another case.
Yes.
That's another second-degree felony with family violence. Yes. So this is what we're going to do. Norma, recall this for the last week in December. State at that time you need to be prepared to make a global offer.
December what?
And state on that case, that family violence, if there's CPS records, you need to obtain those. If there are phone records, mental health records, school records, you need to obtain those.
Yes, Your Honor, I apologize. It's pulling up. I do believe it's not.
And Your Honor,
It's not
I
indicted
also
yet,
have,
so it's just-
Yes.
also have the issue, my client's been on GPS monitor since April. I have the alleged, the second crime, offense that he's been indicted for. And I filed the motion to remove the GPS, but it was in the wrong court because it was not indicted yet. So I would ask court to take up that, but I guess I would have to file the hearing, the motion so we can set the hearing so you can hear.
Yeah, and what I can tell you, if he has all of these cases that are on different dates, there needs to be a good reason for GPS to be removed, because let me just tell you, I don't take any of these offenses as you're guilty beyond a reasonable doubt, because I have not had anything presented to me. But what I can tell you, if you have a felony bond and you are alleged to have committed a new offense, then maybe GPS is where you need to be. You understand? All right. Do you have any questions about anything?
Oh, yeah.
All right. Once you sign the reset form, you are excused. All right. Thank you.
You're fine right there.
Enrique Jacoba.
Apollo?
Huckaba. Okaba.
Right.
Good morning.
Good morning.
I'm gonna have to work on that one. All right. Today's plea deadline date. Have you all reached an agreement?
Not yet, Judge. We've actually filed a motion to suppress on the matter. I think it would be a dispositive matter or motion, excuse me. Pending that, I think there could be a plea after that, but
All right. Is the motion dispositive?
I believe so, Judge. Yes.
All right. All right, state.
Yes.
They're saying that they want a motion to suppress and it will be dispositive. All right. Are you able to do this before the new year? You mean December? All right, Ms. Ferguson, if you can put this for a motion to suppress second week in December, please. State, are you all okay with having this on the 12th? That's a Friday. Would that be easier than the 11th? All right, Norma, put it on December 12th, please. All right, thank you. And I did that because I think it will be easier because we have an interpreter and there are a lot of moving parts.
Sure.
All right, thank you.
Thank you, Your Honor.
And if you could sign an acknowledgement of discovery before you leave.
Absolutely.
Nifa,
Yes, sir.
is Julius Martinez here?
Yes.
All right.
It's here now.
All right, thank you. Okay, you can continue conferring. I just wanted to know if he was here.
We already conferred, Your Honor. On Mr. Martinez, I just want a December 2nd, please.
It's on page 15, Judge.
Thanks.
First one.
And why can't that be done today?
I'm sorry. Well, unless I can come back tomorrow, Your Honor, because I have 8 people waiting for me in Atascosa, so I gotta go from here to Atascosa, and we can come back tomorrow.
All right, complete the plea paperwork and you can appear by Zoom because today is his plea deadline date and he was late for court.
Okay, yes,
Thank
Judge.
you. So that's gonna be 1:30. Zoom,
Okay.
yes. Miguel Contreras. Hi, how's it going?
Good, how are you?
All right, are you all ready to proceed on the MTR?
We are, Your Honor.
Court is calling 2024 CR 012263, State versus Miguel Contreras. Can I have parties announced for the record for the state?
And Lauren left in for Mr. Contreras.
All right, and are you Miguel Contreras? Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Miguel Contreras Jr. who's placed on deferred adjudication in 2024 CR 012263 for the offense of evading arrest detention with a previous conviction on January 23rd, 2025 for a period of 4 years? Is that you? All right, state.
Petition for Porter and Dare County Texas defendant Miguel Contreras Jr. did then and there fail to report supervision officer as directed for the months of July and September 2025 in violation of condition number 4.
How do you plead to that? True or not true? State.
Please abandon their statement, Your Honor.
Any objections?
No, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4? Court will find violation of condition number 4 true. Is there a proposed agreement?
There is,
Yes, Judge, it is for the court to deny the state's motion and alter and amend the conditions for mental health.
he's, not to interrupt, but he's already completed his mental health, so the agreement was for him to do the outpatient dual diagnosis intensive program, is that correct?
Judge, the recommendation and agreement is for him to be placed on the mental health initiative
Caseload and for him to complete the dual diagnosis outpatient program.
Thank you.
All right, thank
That's
you.
what I tried.
All right, do you want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. State your name for the record.
I'm Miguel Contreras.
All right. Mr. DeLeon, do you need a cough drop? Okay. All right. So what has been going on with you?
I was staying at my brother's, but it didn't work out there. Them getting like a power attorney over me or whatever for helping me with this.
All right. So this is, I'm going to give you a choice. I don't know if you'll be successful in this probation or not. My hands are sort of tied with the different programs that I can have available to you because there's a lack of funding. There's a lack of placement. Now, I can follow the agreement that has been reached, or I will sentence you to 8 months in the state jail facility. So do you want me to follow the agreement?
Yes, please.
Okay. So the court will deny the motion. Alternate amend conditions to include MHI plus outpatient treatment with dual diagnosis. And Ms. Abrams, because there may be issues with him, can you make sure that they do the field visits? And so there'll be field visits 1 time per month until further notice. And we're doing the field visits to make sure that you stay in compliance, okay? I want you to be successful at this.
And I don't know if the court could order, but I did tell him to ask for employment resource or help with that as well as housing assistance.
All right, so employment resources and any housing resources. And there is a program, I want to say it's called Build Back Brighter, something of that nature. They can help with housing as well. They're a nonprofit, but they may be able to help you.
I'll Google it and maybe write the information down. for
All right, thank you.
Okay, thank you, Judge. May I be excused?
Yes. All right, what is happening with your case, counsel?
Judge, we had requested some discovery. We did receive some partial discovery from the lab, but we're still in need of the rest of it. I've spoken with the state on that. And I believe we should hopefully work towards a resolution soon, but I don't know how soon it's gonna be for us to get that.
And what discovery is outstanding?
It is gonna be like similar to blood discoveries. The process in which the lab evaluates any PG2. There's gonna be a process, there's gonna be a number of things I've requested from them. And I've received that. I've only received a chain of custody law.
All right, Ms. Ferguson, let's set this for the last week in December. Let's see where we are in discovery. All
Thank
right.
you, Judge.
All right, once you sign the reset form, you excuse. And Mr. Ibarra, what time is court? Why were you not here? All right, so here's the thing. How old are you? You're 18. Court starts at 9. You need to make sure you're here at 9. You understand? All right, thank you. Lincoln Martins. All right, what is happening with Mertens?
Yes, Judge, we're here for discovery. We are in need of about a terabyte worth of discovery. I need to provide a drive to them. I don't have one available today, but I can get one to them. But there's about a terabyte worth of videos that I need.
All right, and your other client is coming back on the
15.
All right. Norma, recall this for the 15th to make sure that they have discovery. All right, thank you.
Thank you, Judge.
Oh, thank you. You too.
Get 2 for 1 today, Judge.
So there's supposed to be a confirmation on whether or not you're hired on the murder case?
There is not yet an indictment or a charge. It's sealed. So
State? Is it criminal trial division or family violence?
criminal file.
Criminal trial division.
Yes,
My understanding, there's a sealed murder case?
I haven't conferred with them, so I don't know, but I believe that there is for Dr. Delmore. Yes.
There's still a pending. He's also on bond for an aggravated robbery case that is arising out of the same incident as the tampering case that I am currently on. And that also is awaiting indictment.
And then I have an indicted case with a tampering and a PCS.
Okay.
Arising out of a completely separate incident.
Totally different incident.
Yes.
All right, so when is this murder case going to be unsealed?
I can reach out to the state prosecutor and find out where they're at with it. It's an at-large arrest, or not arrest, an at-large case. I don't know where they are at in the review, but I can reach out.
Okay.
And just even on the tampering and the aggravated robbery, there's a significant amount of discovery. I'm still sifting through it.
All right, so do you know if he's received all discovery?
On the indicted case?
I'm assuming I've received everything they have. I don't know if I have everything because I haven't seen everything.
Do you have the discovery on my cases?
No.
Okay. But you need to know that, you need that for punishment anyway.
Significant amount of discovery, Judge.
Yes.
We can do a acknowledgement for what we currently have. I don't know if there is anything more to let.
I haven't seen it.
All right,
I know
what's going to happen. This case is coming back at the end of January, whether the murder case is indicted or not, whether the aggravated case is indicted or not. He needs to have discovery on all of those things. Otherwise, if there's a jury trial for these other items and they don't have it, that's not going to be coming into evidence. Okay.
That works, Judge.
All right, thank you. Date end of January, please. All right, January 29th.
And Judge, can I get, since Mr. Garza has bigger fish to fry, can I get off of my cases and let Mr. Perez handle it?
Well, he's hired, are you not?
I'm hired only on the.
Yes, so no.
No?
All right, I'll see y'all back on January 29th.
January 29th. Thank you, Judge.
All right, Miss Henry. Court is calling 2025 CR 009601 State versus Kira Henry. Can I have parties announced for the record for the state? For the defense?
Attorney Alberto Villa for Ms. Henry, and we're ready here.
Oh, thank you. Ms. Henry, you need to show your video.
Sorry, I was trying. I was having a hard time. I'm sorry. I'm here.
All right. Counsel, did you explain to your client the defendant's consent to plea by video conference?
Yes, Your Honor.
All right, Ms. Henry, did you review the document entitled Defendant's Consent to Plea by Video Conference?
Yes, Your Honor.
And did you electronically sign it?
Yes, Your Honor.
Did you understand you have a right to appear in person for this proceeding?
Yes.
And are you waiving the right to appear in person?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to appear by video conference. Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
The court will find that the state is in compliance with discovery. Ms. Henry, did you review the application for community supervision with your attorney? Did you understand it and electronically sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do, Your Honor. And just one other thing, Your Honor. It was supposed to be an application for deferred / community supervision. I think they sent me the regular one, but we can update the court and get that signed as well.
All right. Ms. Henry, are
Yes,
you
ma'am.
applying for deferred adjudication?
Yes.
All right. Any objections to the court writing the words deferred adjudication at the top of the document?
No objections, Your Honor, from the defense.
All right, counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, sure.
Ms. Henry, did you review the court admonishments with your attorney? Did you understand it and sign it? I'm sorry, did you understand it?
Yes.
All right. According to the charge, which is fraudulent use or possession of identifying information, less than 5 items, that's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Henry, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulations of testimony. I'm sorry. The court will find that defendant has knowingly and voluntarily waived her right to jury trial. I'm trying to do 4 things at once. I think I should limit it to only 3. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
Okay, according to the plea, punishment is to be assessed at no fine. All right, so no fine. The state is opposed to your application for deferred adjudication. They recommend community supervision. They're taking in consideration 2025 CR 009623. There's to be restitution to the complainant. And for the record, I'm not related to the complainant that I know of. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, sir.
All right. There's an issue with the paperwork, everyone. On the waiver appeal paragraph, the defendant didn't sign it in both places.
Is it just one signature, Your Honor?
It's one signature. Miss Henry, did you
Yes.
understand? And we'll go with the first paragraph first. There's a waiver of appeal paragraph. Did you review that with your attorney? Did you understand it?
Yes.
Did you electronically sign it?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Your Honor.
All right. So for the record, that's the line that the defendant electronically signed. The part that was not electronically signed was this part, and I'm going to read it into the record and ask if you understand it. It states the above terms constitute our agreement, and there are no agreements not set forth. The defendant and counsel request the court to follow the plea bargain agreement. So, with regards to that statement, the terms of your agreement are $0 fine. State is opposed to your application for deferred adjudication. They're taking in consideration 2025 CR 009623, and there's to be restitution to the complainant. Do you understand that is your agreement and there is no other conditions or agreements that have been reached other than what I've just read into the record, Ms. Henry?
Yes.
Defense, is that your understanding?
Yes, Your Honor.
State, is that your understanding?
Yes, sir.
So with regards to the signature that is needed by your client, but below the line that states the above terms constitute our agreement, and there are no agreements not set forth above, the defendant and counsel requests the court to follow the plea bargain agreement. Is there any objection to the court writing that the defendant was unable to sign due to electronic issues?
There's no objections from the defense, Your Honor.
Ms. Henry, do you have any objection?
I do not, Your Honor.
And Ms. Henry, was it your intent to have your signature placed in that location?
Yes.
Any objection from the state?
No.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There be a TAP evaluation, 120 hours of community service restitution, no contact with the complainant and enterprise at 1123 IH 35 North, San Antonio 78233, and the MRT. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. Seat offered States Exhibit 1 in all attachments.
No objections, Your Honor.
Did you review the waiver and stipulations with your attorney? Did you understand it and electronically sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments, and the court will review the same. All right, after viewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
No, Your Honor, we're requesting a PSI.
All right. All right, I'll need a PSI date.
The week to get. Exactly. When it comes into a tree. And then we stay off site.
Sorry, what date? The 12th. All right, you'll be back on Zoom for PSI
Once.
and top evaluation on January 12th.
And will they be getting a hold of her, Judge?
Don't leave the don't leave the Zoom because probation is going to Zoom in to speak to you. And what did you say, Mr. Acevedo?
That's all I was asking, Judge, if she was gonna speak and schedule those dates.
Yes, so I'm gonna put you in a breakout room.
Okay.
And
Thank
then
you,
you
Judge.
can be excused from the breakout room.
Thank you, Your Honor.
You're welcome.
Thank you.
You're welcome. All right, Jorge Guevara. Counsel, there's no application.
There's not, Judge.
Okay.
Good
Good afternoon. All right. Court is calling 2024 CR 012217 State versus Jorge Alberto Cuellar Guevara. Can I have parties announced?
Judge Rivera for the state. Orlando Castañon for defense.
And are you Mr. Guevara?
Okay.
Yes, is that you?
Yes, ma'am. I'm sorry.
All right, no problem. I'm sure I'm probably mispronouncing it. I'm sorry. Counsel, have you received all discovery?
Yes, Judge.
Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Guevara, did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented? Mr. Guevara, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand you're charged with online solicitation of a minor for sexual conduct?
Yes.
That's a second-degree felony.
Yes.
Range of punishment is anywhere from 2 to 20 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Judge.
Mr. Guevara, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
100%.
All right, if you're not a US citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to a jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 3 years. I know that it was a cap of 5, but there's a line drawn through that. So you all are proceeding with a sentence of 3 years.
Yes, Judge.
Right, there's $1,000 fine, no applications, and Chapter 62 compliance. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Judge.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motion?
No, Judge.
Then to the offense as charged, how do you plead?
Guilty.
State, any evidence?
For state exhibit 1 and attachments.
No objection, Judge.
All right. Did you review the waiver and consent to stipulations of testimony and stipulation with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. And state, you may be excused unless there's another matter.
I can just stay here, Judge. It's my only case.
Okay. People
So no
love being in the 187. I like it. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
All right, why should I follow this plea?
Judge, he has no prior criminal history. He's accepting responsibility. We discussed some defenses to this case, but in light of I think all the facts, I believe that he thought this is in his best interest to pursue, and as such, we're asking you to follow this agreement.
What were you thinking?
I wasn't thinking.
And how old are you?
34. I was going through rough times. It's not an excuse. I'm defending.
No, and let me just tell you something.
Yes, ma'am.
So obviously, if this were an actual child on the other end of the line, you were trying to take advantage of them, right? And I'm just telling you, you cannot build your happiness off somebody else's misery. And if that were a child, and if you were to actually have met that child,
No, yeah.
You understand?
Big answer. Yes, ma'am.
all right, the court is going to find you guilty, sentence you to 3 years in the prison. There's $1,000 fine. Chapter 62 compliance. There's to be no residing in households with minors and no unsupervised contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal because this is a felony conviction. You're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you, ma'am.
Counsel, you know, they always say, if somebody says, yes, 100%, that means they're telling the truth. If you ever watch Maury Povich, you know, when they're saying you're not the father, whenever somebody says, I'm 1,000% sure, anytime they go over 100%, you know, it's not true. So he really meant that when he said 100% satisfied.
Thank you, ma'am.
All right, thank you.
Holidays, ma'am.
Oh, thank you, you too. All right. Ms. Abrams, are you ready?
Yes.
Alfonso Lopez.
Thank you, Judge.
You're welcome. And it's an application. Court is calling 2025 CR 004627, State versus Alfonso Lopez. Can I have parties announced for the record?
Trey Maurer for Mr. Lopez.
And are you Mr. Lopez?
Yes, ma'am.
Counsel, have you received all discovery and did you review that with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Lopez, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, state has to wait the enhancement element.
We have no objections.
All right. Mr. Lopez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, you're charged with theft of property less than $2,500 with 2 or more convictions as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Do you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Lopez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the state jail facility. There's an $800 fine. State is opposed to your applications. They're taking in consideration 2025 PF 42484. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
There were not.
Then so the offense is charged. How do you plea? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor, state upper state exhibit 1 and all of that.
No objections.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. After reviewing the same, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you requesting a PSI?
We are, Your Honor.
All right. It will be 8 to 12 weeks, or if you would like, it could be shorter. And what will end up happening, I'll just hear any witnesses you all would like to present.
I think we would prefer the shorter one. I would anticipate just having one witness, Your Honor.
All right, Ms. Abrams, this is a waiver of PSI and TAP evaluation.
Okay, good, great.
All right. Ms. Ferguson?
I'm sorry, Your Honor, I misunderstood. So that means that you would not do the PSI. It would just, okay, I apologize. I think we, let me kind of take a step back.
Sure.
Go for my client real quick.
Okay. Sure. All right, thank you. All right, yes.
Your Honor, I believe we will waive the PSI and just present the one witness when we come back.
All right, how much time are you requesting, counsel?
As far as when we come back,
It would have to be in December.
maybe that first week of December, Your Honor, or second week of December.
All right, Ms. Ferguson. All right, I'll give you your date. All right, do you prefer the first week or the second week?
The second week, just so I can ensure that I can get my witness down here, Your Honor.
All right, so it can be the 8th, the 9th, or the 11th.
The 9th works for me, Your Honor.
All right, so we'll come back on December 9th. At that time, I'll make a decision on your requests based upon any evidence that's presented to the court, okay?
Yes.
All right, thank you.
Thank you, Your Honor. May I present the rejection to the
Yeah.
case?
David Allen Hernandez. Court is calling 2024 CR 009659, State versus David Allen Hernandez. Could I have parties announced?
Those are for the state.
Ryan Arnett from Mr. Hernandez.
And are you Mr. Hernandez? And counsel, you ready to proceed on the motion?
Yes, Judge.
All right, Mr. Hernandez, did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it? Are you the same David Allen Hernandez who was placed on community supervision in 2024 CR 009659 for the offense of possession of a controlled substance, penalty group 1 to 4 grams, on November 21st, 2024, for a term of 10 years? Is that you? All right, state.
Violated condition number 4, in Bexar County, Texas, the defendant David Allen Hernandez did then and there fail to report to the supervision officer as directed for the months of May, June, and July 2025 in violation of condition number 4.
Just one moment. I need a box there. For a motion to revoke. To that, how do you plead? True or not true? I'm sorry?
True.
State will waive the remaining violations.
Any objections to the state's waivers?
No objections.
All right. Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, and sentence you up to 10 years in the prison and up to a $2,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4?
Yeah.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement is to deny state's motion, continue on probation, but alter and amend conditions for state advancement on the Bexar.
And what is occurring with the new number 1s that are in the document?
So the new number 1, the engaging is not active with our office, but this act is being rush filed so that we can.
All right. So, Mr. Hernandez, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
David Allen Hernandez.
Why didn't you report?
Me and my girl fell on bad times. She got pregnant. I was really dealing with that situation. I was my probation. And we were kind of out. Lost our spot. We were standing in the vehicle. Our vehicle, 2 other kids. And that's really why I started focusing more on the babies than the report.
All right, and where has that?
She's got an apartment now.
No. I mean, the fact that you were focusing on the children, which I don't know if that's true or not. I'm just listening to what you're saying. So what did that accomplish by not reporting? And so it appears that she's able to function without you, because how long have you been in custody?
3.5 months.
3.5 months. So she's been able to get a place without you, a place for the children without you. And are these your biological children? All right. So I don't understand why you should be continued, because you've pled true to not reporting for the months of May, June, and July of 2025. And we are here almost in December. So there are a lot of months that you didn't report. So what have you done since you've been on probation?
I stayed away from drugs. This is on probation for. I went to that lot of recovery. That was.
Did you complete lifetime recovery successfully? Probation?
Yes, Judge.
What are you recommending?
And in our initial conversation, I recommended what the ADA and defense counsel has on the court summary, they wanted to alter and amend for status.
So my problem to both parties, I don't know if he's been clean or sober or not, because he hasn't reported.
Yes, Judge, I understand. And
if necessary, he could undergo a new TAP evaluation, and if substance abuse is what the court deems necessary, then we understand that. We just thought ISF cognitive would be more appropriate in this case because we thought it stemmed from maybe not being in the greatest spot in his life, but not understanding how to make the decisions to prevent being in those spots and how to come out of those spots without any sort of harmful thinking to either himself or others.
But that's what lifetime recovery teaches you. When you're in the sober support meetings, that's what they teach you to make better decisions. I don't think he's appropriate for probation. He's been gone. So, yes.
I believe that he would be a good candidate for probation. I think that it's not that he made a mistake, he made a decision and it was a bad decision. And he's now here on this MTR. He understands the gravity of not reporting. It's not as simple as just not reporting and continuing on probation. He understands that he must be reporting as directed by the probation department. He's willing to undergo the ISF cognitive for 90 days inpatient to correct his thinking to continue to be a good candidate for probation. And he is really looking forward to correcting his own behaviors for his future children. As he said, his girlfriend is currently pregnant with twins. Those will be his biological children. And then also the 2 children that he takes care of that are not his biological children.
How old are you?
21.
So you should know you need to report.
Yes.
And so here's my question. Were you arrested or did you turn yourself in? Where?
Leaving a restaurant, taco restaurant, getting taco.
Probation, do you think he would do well to be continued or no?
He doesn't report or upon the first infraction, we file a motion to revoke.
All right, here's the thing. I'm going to give you 2 choices. You only have 2 choices. There isn't a third. Don't ask for a third. I can revoke you. I'll sentence you to 3 years in the prison. You'll get credit for any successful inpatient treatment because legally I'm required to give that. Or I can continue you and you're going to ISF. Which do you prefer?
I'll take the ISF for trying to see my kid born.
Oh, so here's the thing. I don't know what the wait time is for ISF, but you will be in custody and be transferred. All right, the court will deny the motion. Alter and amend conditions to include ISF cognitive. Is that the local one, Ms. Abrams, or no? Okay. Is there anything else he needs? Is there anything else you need from the court to be successful?
Yeah. I can help with that. I really need help.
Help with what?
I'm thinking how they said for Kentucky.
And then Judge, just for the record, when he was saying that, I was just talking to him. Whenever I was appointed, it was notified on the appointment letter that he was homeless. He would like to be recommended for any housing services as well to help him with housing going forward.
All right, upon release, resources for housing and employment. And the court previously required parenting classes. You need to make sure you complete those. Do you understand? All right, we can go off the record. Here's the thing. You better make sure that you report. Do you understand? Because being on probation doesn't mean I'm on probation. I won't commit any new offenses, so it's all fine. That only works usually for municipal court with tickets. You understand? All right, good luck to you. You're welcome.
And then Judge, do you know if those parenting classes, can they be completed in ISF or?
You'll have to speak to probation because sometimes those classes are transitional there, which ones they have.
Okay, thank you, Judge.
All right, you're welcome. All right, Julius Martinez. Ms. Correa, we're ready.
Yes, Your Honor. Gentlemen,
Court is calling 2025 CR 010562, State versus Julius Martinez. Can I have parties announced for the record? Well, that was quick.
Info Carrillo for Mr. Martinez.
Are you Mr. Martinez?
Yes, ma'am.
You have any objection to your attorney appearing by Zoom?
No, ma'am.
State any objection? All right, did you review the discovery acknowledgement with your attorney? Did you understand it?
Yes, ma'am.
And defense, did you review all discovery with your client?
I did, Your Honor.
And have you received all of the discovery?
I did, Your Honor.
Court will find that state is in compliance with discovery. Mr. Martinez, did you review the application for deferred adjudication or community supervision with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes.
Mr. Martinez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with assault on a public servant as a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
In my opinion, he is competent.
Mr. Martinez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen by entering this plea, you will be deported and denied naturalization. Did you understand?
Yes, ma'am.
And re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a $2,000 fine. State recommends deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
It is.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 4 years. There'll be a TAP evaluation, 200 hours community service restitution, no contact with Bar House, BAR House at 820 North Alamo, hostility management course, and alcohol awareness course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plea?
No contest.
State, any evidence?
State offer, state's wanted.
No objection, Your Honor.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the sign. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, on that particular night, my client, it was something that he could, if we wish, he could take back. Wasn't a fight. He didn't intend to hit the police officer. the officers were trying to pull him apart. My client just swung and they hit the other one and unfortunately hit the officer. He's a good man. He works and he just wants to put this behind him and live up to the obligation that he will inherit when, if your honor puts him on deferred probation.
All right. And State, is there anything you wish to add? All right. How old are you?
I'm 19 now.
All right. And what time of the day was this?
It was around 2 in the morning, maybe.
And this goes back to what I say. Nothing good happens after 10 p.m. You should have been at home. Do you live with your mom?
No, ma'am, I live with my wife.
You should have been. Was your wife with you?
Yes, ma'am. It was her birthday. That's the only reason we were out.
And you're not supposed to be at a bar anyway because you can't drink, but you were intoxicated, according to this. And how old is your wife?
She's 21.
And do you all have any children?
No,
You're not ready yet.
not at all.
So I can tell you as a part of your conditions, I'm going to order that you're not allowed to go into any establishments where their main source of business is the selling of alcohol.
Yes, ma'am. That's perfectly fine.
All right. Because I'm reading in the police report, people were trying, your friends, probably your wife included, were trying to tell you, let it go, leave it alone, let's move on.
Yes, ma'am.
You ruined her birthday.
Yes, ma'am.
I hope you're making it up to her.
Yes, ma'am.
And I hope she brings it up anytime she wants something. She can say, remember my 21st birthday. It wasn't a good time. Okay.
Yes,
Are you employed?
yes, ma'am.
What do you do?
I do fiber optic for light fiber.
Okay.
I drill Wi-Fi in the ground. It's just basically I put Wi-Fi.
All right. See, never lower your job status by saying just basically I do this. You want the company to know that you're indispensable. You understand?
Yes, ma'am.
All right. All right, this is what the court will do. Court is going to sentence you to a $2,000 fine. That will be probated. 2 years deferred adjudication. Uh, 200 hours community service restitution. I'm going to order the hostility course. Once he's completed that, 100 hours will be deemed satisfied. And I'm going to order the alcohol awareness course. Once you've completed that, 20 hours will be deemed satisfied. The remaining 80 hours will be satisfied through completion of sober support meetings. So for every sober support meeting you complete, an hour will be deducted from that. Do you understand? So probation, I'm ordering sober support meetings. There's to be proof of employment within 40 days, no employment as a home health care provider or with minors. Field visits 1 time per month for 2 months. No contact with Bar House at 820 North Alamo, 78215. And there's to be no entry unless it's for employment to label fiber optics. No entry into any establishment where the business is primarily the sale of alcohol. So if you're going to a place and it's not a bar, you can go there.
Yes, sir.
So Red Lobster, Olive Garden, Cheesecake Factory, and any other restaurant like that. But if it's a bar, no. You understand?
Yes, ma'am.
Probation, is there anything else that's needed? Oh, I'm sorry, regular reporting by Zoom or in person. Regular random UAs. Well, we'll just do regular UAs because I know how employment for that company is.
Your Honor,
Yes,
my client is not a resident of Bear County. He lives in Uvalde. And we were gonna ask for the probation to be transferred to that county.
all right. Is it Uvalde County?
I think it is.
All right, transfer to Uvalde County. And probation, if for some reason they don't do field visits there, then that's okay. Probation, is there anything else he needs? Is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, sir.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
All right, we can go off the record. Remember what I said. And have you ever resided in Berry County or no?
I used to live in Leon Valley.
All right. So here's the thing. When you go to another place to visit or as a tourist, you're sort of like a guest to that county. So don't go to that county or somewhere else as a guest and cause problems. You understand?
Yes, sir.
All right. Good luck to you in this court to be successful on probation. Communication is key. If there's an issue, let your probation officer know about it. If you feel as they're not addressing it, you can always come back here, okay?
Yes, sir.
Whatever you do, don't disappear.
Yes, sir.
Report, okay?
Yes, sir.
All right.
Thank you, Judge.
You're welcome, and thank you for addressing appropriately.
Yes, sir. Thank you.
All right, who else do you have, Miss Carrillo?
I have a bond for Miss Medina, Valerie Medina.
All right, could you all pull the bond on that?
She's been in the hospital, Your Honor. And we have a trial date, December 4th, I believe.
Yes. All right. The court will set your bond at $5,000. The court will grant your application for deferred adjudication. Court will ask that fees be waived. There is to be, yes?
Your Honor, is it a PR bond? It's not a
Yes.
deferred?
No, it's a PR bond. The fees are being waived
Yeah.
because there's a 3% fee to PR bonds.
I believe you mentioned deferred adjudication, Your Honor.
Did I? Oh, I'm so sorry. Thank you. No. It's a $5,000 bond. I think I said that because in the paperwork it says deferred, but our bond fees will be waived. And there is to be drug and alcohol testing. And I will ask that the fees are waived. Is there anything else you need from the court with regards to bond? And I know you've been in a hospital, so how is your health?
Good.
Okay.
My medication.
Okay. All right, so they'll have you do the drug testing and Ms. Ferguson is going to give you the reset form. Once you receive that, you are excused. And thank you for letting me know I said that. I didn't mean to say that. All right, thank you.
Thank you, Your Honor.
You're welcome.
May I be excused?
Yes. Alvarado? So where are we on discovery on this case, Mr. Behrens?
I've seen the file, Judge, but the state, I think, needs time to contact their victim and consult with them before they make me an offer. So I don't think it's gonna be a big deal, but and just so the court knows, we're out of state between 12/12 and 1/5. Glad to appear by Zoom if that's what the court wants.
Yes, I believe Ms. Alburn intends to contact.
All right, so you all need to confer off docket. Ms. Ferguson, set this for a plea deadline date the second week in December.
Can I appear by Zoom if we're leaving on the 12th? I don't know.
Oh, it's going to be set for December 8th.
Okay. Got it.
All right, you'll be back on December 8th. Your attorney will be present. And once you sign the reset form, you're excused. Thank you.
Thank you, Judge.
You're
Am
welcome.
I excused?
Yes. Lampkin, come forward. Hello. How are you doing? All right. Is he med compliant? Do we know?
I believe he is, Your Honor. He did have an issue with one of the meds he was taking. He had a conversation with the probation officer about that. But other than that, he has been compliant with all of his meds and he hasn't been acting out. I do believe there was one incident where he didn't like his meds and he expressed that incorrectly. But other than that, there hasn't been any issues and I haven't received any violation reports.
Probation,
Yes, Judge.
is he med compliant?
Judge, hard to know, I indicate whether it is or it isn't.
She's trying to get objective proof of that. Just let her ask.
So here's the thing. We're here, and the reason why we're here is because you have new cases, right? And those new cases are alleged to have been committed when potentially you were not med compliant. So that's why I'm always concerned and want to know if you're med compliant. Because if you're not, that will impact your bond. You understand? Because part of my job is to set conditions for bond in a probation that will make sure that you're successful, but also protect the community. Do you understand? All right. And I know we were supposed to have a contested hearing today, and everybody agreed that witnesses may appear by Zoom. I'm assuming nobody's ready for a contested today.
We did file an agreed motion. It was properly accepted, Your Honor. We are asking to reset that to either like next Monday or Tuesday, or the week after that on Wednesday or Monday, whatever's better for the court.
State defense, when do you all want the contested hearing?
And I don't know what their calendar looks like, but I know the dates that I'm available right now. Or Wednesday. Yeah, the 1st or the 3rd would be good for us.
All right, December 1st. And that will be a contested hearing. Witnesses can appear by Zoom. All right, once you sign the reset form, you'll be excused.
Do you want the motions, Your Honor, or we'll just do a form?
All right, Marino. Hello. Everybody, yes, bring him up. Everybody's coughing up in here. I mean, is there something going on? Something's right in the back of my throat. I can't quit talking.
There's just massive COVID. It's everywhere.
Hey, I have never had COVID. I'm not trying to get COVID. Well, you know what? Let me reverse that, because people always want to know who patient 0 is, and hey, maybe we want to do something to figure out what's in their blood. So I've had COVID several times. All right, this is final discovery.
All righty. Judge, I've got all the discovery I need. I need due diligence. We're close to resolution to the case. So we just need one more setting, Your Honor.
All right. Norma, if you can set this for 30 days for a plea deadline date. All right, December 18th.
All right, Judge.
All right, thank you. How old are you?
18.
All right, be sure to stay in contact with your attorney. All right, thank you.
Thank you, Judge.
Adrian Garcia. All right, today is plea deadline date. Have you all reached an agreement, or is this going to be a jury trial?
It's going to be a jury.
How long do y'all expect this to last? Norma, I need a jury trial date, 3 days.
Yes.
Sure.
Since the day I got arrested, I was whisked away in the cop car. I spent 4 months in jail, not talking to anybody. I barely spoke with my lawyer, but twice, less than 25 words, both court dates. I've seen him talked to the district attorney. Even less words than that.
Mhm.
So I just want to be heard, Your Honor, that it was a self-defense case.
No, let me stop you right there.
Okay.
So with regards to no. Here's the thing, with regards to self-defense. You're charged, according to this, with assault, family violence, choking. Yes. So with your attorney and his conversations with the state, maybe he's received all the information he needs to receive from them. For him to say that you're requesting a jury trial means that an offer has been tendered and you've made the decision that you do not want to accept the state's offer and there is no agreement that's been reached. Is that correct? I don't want to know what the offer is. My only question is,
Offers, I just want to be heard, Your Honor,
Oh.
that,
could you tender him the offer, please?
yes.
So he's gonna continue to offer, then you can let me know whether or not you have accepted the offer.
I don't mind going to trial. I'm very confident that
All
I
right,
will-
then we're gonna give you a jury trial date.
Thank you. I just want to be heard that I think I would be better off in probation, not because I think I'm guilty, but because.
But let me ask you this, and let me explain something to you. Number one, what you've been charged with, and I don't know anything about your case. The only thing I know is what's in the indictment. Wait a minute. All I know is what's in the indictment. What's in the indictment is they're charging you with assault, choking. Now, normally assault, choking, family is a third-degree felony. They're proceeding on you as a second degree. So that means that they're saying that there's something else that they're alleged that's in your past. Either what's in your past is another family violence case, or either they're enhancing you because you've been to prison before, right? Now, with regards to making this a second degree instead of a third degree, if there's a jury trial, or if the state has to prove that, your attorney probably has already told you that's proved with documents. Whatever that case is, there is normally not a retry of that case. For example, if somebody's been to prison and the state wants to use the fact that they've been to prison to bump up their range of punishment, that case doesn't get retried. All they do is bring in what's called a pen packet. They present it to the jury and they have to prove that that pen packet is actually yours. And they bring that to a jury. And then with the case, whatever you're on for, that's a part of the indictment that they're accusing you of. For example, with assault, family choking, of course, they need a complainant. That's the person who's saying you did this.
I called
Then
police.
they need that person, they need an on or about date, and they need somebody to say it was you. And then the jury will hear that evidence and the jury will make a decision on whether you're guilty or not guilty. Whether or not you believe you deserve probation or not, that's your belief. If you go to jury trial, if the state are able to prove what they're able to prove, and I don't know what that enhancement is or how they come by that enhancement, based upon that, you may or may not be eligible for probation from a jury. But whether or not you tell your side of the story or whatever, that depends on you. You have a right to testify or not testify. The state can't call you as a witness to testify, but it appears that you all are at an impasse. It appears that you want probation. It appears the state is not offering probation. So your plea deadline date has expired and you will be set for jury trial. And you all think this will last 3 days? Ms. Ferguson, I need a 3-day setting for a jury trial, and counsel, if you'll do acknowledgement of discovery. Judge, it could be February 24th. I need it in January. We can do January 13th. You say 13th? All right, your jury trial date is going to be January 13th. You're going to be brought over in whatever civilian clothing you have at the jail. If you wish to be attired in something different, there'll have to be a clothing exchange. Counselor, the new rules at the jail is that the clothing exchange must be requested within 72 hours of trial. So you can't do it 2 months in advance, or you can't do this in December. It'll have to be exactly 72 hours.
I have to request his clothing?
If he wants to do a clothing exchange, you have to file it.
Yeah, I mean, my shorts are torn because my son Fisher did it.
Oh, okay.
Okay. All right, thank you. Christopher Mazuka. Hi,
Good afternoon, Judge.
been a long day.
Has been, I know, nearly there.
Yeah. And am I gonna be seeing you tomorrow
No, Judge.
for mental health? It'll be Christine.
Correct, Judge. Yes.
Okay. All right. What are we here for?
Motion to revoke probation, Judge.
And are you all ready to proceed on the motion?
Judge, I do think so Melissa was the one that conferred on this, but I believe the parties had contemplated having a TAP evaluation done in the MIT while in custody, and then depending on those results, we see how we move forward. I don't.
That's what we're more so thinking, Judge. But in the interest of expediting this matter, my client feels comfortable pleading true with the hopes of treatments, and then having the TAP and mental health evaluation in custody, and whatever the recommendation is by the professionals doing those exams, that the court may order that.
All right. Court is calling 2025 CR 003825 and 2025 CR 003824. State versus Christopher Anthony Mazuka Garcia. Could I have parties announced for the record for the state?
Lauren Espinoza for the state.
For the defense?
Renee Munoz on behalf of Mr. Masuko Garcia.
And are you Mr. Mazuka Garcia?
Yes, Your Honor.
Did you review the documents in each of those cause number entitled motion to enter adjudication of guilt and revoke community supervision and First Amendment motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, Your Honor.
And in the cause number ending in 24, are you the same Christopher Anthony Mazuka Garcia who's placed on deferred adjudication in 2025 CR 003824 for the offense of assault peace officer judge on July 8th, 2025 for a period of 3 years?
And it was an attempt to commit peace officer, Judge, I believe.
All right, so this is incorrect. All right, the motions to revoke the charge is incorrect. And let me see. And it's in each motion, it's not listed appropriately. Are there any motions to change assault peace officer to attempted assault? Any objection?
No objection, Your Honor.
All right, so in each of the cause numbers, 2025 CR 003825 and 2025 CR 003824. Are you the same Christopher Anthony Mazuka Garcia who was placed on deferred adjudication for the offense of attempted assault of a peace officer or judge on July 8th, 2025 for a period of 3 years? Is that you?
Yes, Your Honor.
All right, state. And are you proceeding on the same violation in each cause number? All right, you may proceed.
By condition number 4 in Bexar County, Texas, the defendant Christopher Anthony Mazuka Garcia did then and there fail to report to the supervision officer as directed for the months of August and September 2025 in violation of condition number 4.
And how do you plead to true? How do you plead to that in each motion?
Your Honor.
Violated condition number 4 in Bexar County, Texas, the defendant Christopher Anthony Mazuka Garcia did then and there failed to report to the supervision officer as directed for the month of October 2025 in violation of condition number 4.
How do you plead to that?
True, Your Honor.
And that's true in each motion?
Yes.
Is that true in each motion?
Yes.
All right.
State will waive the remaining.
Any objections?
No objection, Judge.
All right, in each cause number, did you understand by pleading true to violations 4 and 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison in each cause number and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violations 4 and 4?
Yes, Your Honor.
In each motion, the court will find violations 4 and 4 true. Is there a proposed agreement?
Yes, but the recommended agreement from the parties is to deny state's motion, alter and amend to add conditions at the top with Smith. Continue on probation, and then we will TIC the new burglary of the building and then have the misdemeanor.
Okay.
That is our understanding as well.
And what is the felony?
The number is going to be 2025 PF 43911.
And counsel, the misdemeanor, when will that be taken care of?
We can get that taken care of by next week, Judge. I think by tomorrow will probably be a little bit late notice, but next week we'll be able to reach, next week's Thanksgiving. I believe, Judge, just to say confidently, I think the week after Thanksgiving, that week of December, the first week of December, we can definitely get that in.
All right. And probation, is this your recommendation?
Yes, Judge.
All right. You want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right. You can lower your hand. State your name for the record. All right. And where have you been? Why haven't you been reporting?
My grandpa died and I got into a tough time for my mom got when she went to the hospital and it became too much for me to be at home alone with my dad. We got into an altercation and so I removed myself from the situation given that I had assault charges. I didn't want to end it, so I had been staying with a friend, but only like at night, not during the day or anything. During the day he goes to work, so I wasn't able to be there. So I was with my girlfriend, really just around in the streets, not really doing much. We spent a lot of time at the park, just just talking about our future, what we wanted to do. I was actually doing really good. I had already started employment. I was helping out right now, doing lawns. We were mowing lawns and we already had started doing so she was going to NNA meetings and I was starting to join her out of the volunteer because I knew I was supposed to be going to something, but I didn't understand how to get to where I needed to go or how I was gonna go about trying to do my probation. I went to my orientation, but upon leaving my parents' house, I lost my paperwork. I was just confused and scared of what to do. I thought I was gonna go back to jail immediately as soon as I went in. I know I didn't go about it the right way. I just want help. I want to get back on the right track again. I want to get back to work and I want to get back to my girl. I have substance abuse issues. I've been working on it and she's been a rock with me on that. Like we've been pushing each other further and further. I fully want to stop using completely. I don't want that to be a part of my life or my future. I know I'm changing from a boy to a man and I'm trying my hardest. I really just want to help more.
Okay. All right. This is what the court will do. The court will follow your agreement, deny the motion, alter and amend conditions, take into consideration 2025 PF 43911. There's to be TAP evaluation in custody, follow the recommendations, mental health evaluation. And let's do a referral to felony drug court. I know they're at capacity, but at some point in time, maybe they'll have room for him.
Do you want that felony drug court eval to be completed after the tap?
Yes. The felony drug court is a program. It's very intensive, but it'll help you if there's mental health issues. It will help you with housing. It'll help you with employment, and it'll help you with any type of drug addictions. Okay. You're welcome. So there's to be no residing in households with minors. And probation, if you can help him with resources for employment and housing. Is there anything else that you need?
I wanna. Already can help from doing, no, I think you're thorough with what you're doing for me. Thank you, Your Honor.
Okay, so here's, we can go off the record. Here's the thing about this court. When you're on probation, one of the worst things that you can do is just disappear. If you have an issue, just let probation know about it. If they feel like they're not addressing it,
How would I do that if I?
they have contact information for you. If for some reason you can't get in contact with him, that with him or her, you can always come back to the court. I'm always here.
So I would just come to this courthouse and then say.
Yes, but first, you need to try getting in contact with your probation officer, okay? But coming to the courthouse,
I don't even know who my probation officer is.
all right, they're gonna make sure you know. And here's the other thing. We're only here Monday through Fridays, okay? Saturday, Sunday, I'm not here. If I'm here on Saturday or Sunday, that's not good.
You're working too hard at that point. Judge.
Yes.
No, you are a very hardworking judge.
All right, thank you. Is there anything else?
Nothing further, Your Honor. Thank you for being so thorough, for allowing him this opportunity.
All right, good luck to you. All right, on Matthew Martinez, is this an application? All right, and counsel, on this case, are you going to want a PSI report?
Yes, Your Honor.
All right, I need a date for PSI and TAP. Court is calling 2025 CR 0068882, State versus Matthew Stephen Martinez. Can I have parties announced?
In Galloway for state.
Normal Doctor representing Mr. Martinez, Your Honor.
And are you Mr. Martinez?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Martinez, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes,
Did you review the true bill of indictment with your attorney? Did you understand it?
yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented? Any objections?
No, Your Honor.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand in count 2, you're charged with assault on a peace officer? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you were giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand that the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in the prison and up to $10,000 fine? Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Martinez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, or reentry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at a cap of 5 years in the prison. There's a $2,000 fine. The state opposes your application for community supervision or deferred adjudication. There's to be restitution to the complainant, if any, and the state is proceeding on count 2. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to count two, how do you plead? Guilty, not guilty, or no contest? State any evidence.
I have no objections, Your
All
Honor.
right, state you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find that there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. This will come back for a TAP evaluation on January 13th, 2016. I'm sorry, 2026. I will base my decision on your application on the PSI and whatever evidence is presented. Do you understand? Do you have any questions about anything?
No.
All right. Probation is going to give you instructions. Make sure you meet all of those appointments because there's an appointment with your probation officer. Then there's a separate appointment that's usually scheduled for TAP evaluation. Okay.
Yes.
All right. So make sure you sign the reset form and speak with probation before you leave.
Thank you,
Thank
Judge.
you.
May I be excused?
Yes. Bailey Corley. Court is calling 2025 CR 014781, State versus Bailey Corley. Can I have parties announced for the record?
Martin Guerra, attorney for Bailey Corley.
And are you Bailey Corley?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. All right, is this a felony information?
It is, Your Honor.
I don't have the waiver.
I believe it may have been stapled to you this, one of the packets. I know we went over it, we signed.
Okay, let me see if it's stapled to another document. All right, did you review the waiver of indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you understand you have a right to have a grand jury review the evidence in this case and make the decision on whether or not to hold you over for trial?
Yes, Your Honor.
Did you understand your attorney has certain rights? Namely, he has the right to the passage of 2 days once he's presented with the information, and he has the right to have 10 days to prepare for trial. Did you understand?
Yes, Your Honor.
By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review the information?
Yes, ma'am.
Waiving the information, counsel?
Yes, Your Honor.
State proceeding on the information as presented?
Yes, Your Honor.
Mr. Corley, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with the unauthorized use of a vehicle. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe so, Your Honor.
Mr. Corley, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
I'm sorry, if you're not a US citizen, you will not be allowed to be naturalized. You will be deported and are not allowed re-entry. Did you understand?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at an $800 fine, 1 year in the state jail facility. There are no applications. This will run concurrent with 2023 CR 2218. State is taking in consideration 2025 PF 41097. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest? State any evidence.
No objections.
Right. Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments, and the court will review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Respectfully, Your Honor, we ask you follow the plea agreement.
All right, the court will find you guilty. The court will sentence you to an $800 fine, 1 year in the state jail facility, give you credit for any time served. Take in consideration 2025 PF 41097. There's to be no residing in any households with minors. There's to be no unsupervised contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, Your Honor.
Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
Next, we're going to proceed in 2023 CR 2218. Mr. Bailey, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
Yes, Your Honor.
Are you the same Bailey Alexander Corley who was placed on deferred adjudication in 2023 CR 2218 for the offense of possession of a controlled substance, penalty group 1, 1 to 4 grams on June 21st, 2023 for a period of 4 years? Is that you?
Yes, sir.
State.
On or about the 15th day of October 2025 in Bear County, Texas, the defendant Bailey Alexander Corley committed the offense of unauthorized use of vehicle in violation of condition number 1.
How do you plead to that? True or not true?
True.
Violated condition number 4 in Bear County, Texas, the defendant Bailey Alexander Corley did then and there fail to report to the supervision officer as directed for the months of August 2025 and September 2025 in violation of condition number 4.
How do you plead to that? True or not true?
That is true, Your Honor.
State will waive the remaining.
Any objections to the waiver?
No, Your Honor.
Did you understand by pleading true to violations of conditions 1 and 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violations of conditions 1 and 4?
Yes, Your Honor.
Court will find 1 and 4 true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement is to grant state's motion to revoke and turn adjudication of guilt, sentence to 3 years TBC and run concurrent with cause number 2025 R 01471.
All right. I don't know why I should follow your agreement. And let me just explain to you why. This is your third motion to revoke. Your first motion to revoke was a violation of condition number 38. Your conditions were altered and amended to include SATA. That was December. Then you came back in November. In November, it was a violation of, November was this, you pled not true. And now we're back here and you have pled true to violations 1 and 4. I don't know if you've learned anything. I don't know why I should just give you 3 years.
Your Honor,
Yes.
that is what we're asking is for the revocation of the 3 years. Is obviously he knows that he made mistakes, or rather he knows he made poor choices. He's accepted responsibility for that. He's not asking to be completely excused, but he has participated already in SATF. And unfortunately, through his own addiction and his own poor choices, they continue to happen. However, he's been in custody since October 15th. Wants to put this behind him.
And I'm assuming he's going to be asking for credit for successful completion of SATA.
Yes, sir.
All right.
He and again, if you look at his criminal history, you'll see that unfortunately there is a rather small time frame where the case has occurred, but he doesn't have an extensive criminal history.
All right. This is what the court is going to do. Court is finding 1 and 4 true. Is there anything you wish to say? Court is going to find you guilty, revoke. This will run current with cause number 2025 CR 14781. The court will give you credit for any time served. The court will give you credit for a successful completion of SATA. The court will sentence you to 4 years in the prison. There's to be no residing in households with minors, no unsupervised contact with minors, and I'll request the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are in deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, we can go off the record. You're going to have to make better choices, right? You could have been killed running from the police across lanes of traffic. You could have ended up killing somebody else because they're trying to avoid hitting you. And all because you took something that did not belong to you. If you don't make better choices, you're going to find yourself living at somebody's prison, somebody's jail, or the next time you run across the freeway, you may end up getting hit by a vehicle. You understand? All right, good luck to you, okay?
Thank you. I appreciate you being so fruitful today.
All right, you're welcome.
Thank you.
Carissa, do you all have any information on Jonathan Godina? And Norma's not here. All right, the court is calling 2025 CR 009206, State versus Carissa Brooke Ramos.
Yes, good. Nobody was handling it. Megan stepped out.
Oh, thank you. All right, could I have parties announced?
Joseph Stateson standing in for Monica Guerrero. She's in Del Rio Federal Court. And Ms. Ramos, will you give this judge permission for me to do this in place of Ms. Guerrero?
Yes. All right, counsel, had you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Ramos, did you review the application for community supervision with your attorney? Did you understand it?
Yes.
And did you sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it? All right, state, it appears that you're proceeding on the lesser included offense of assault bodily injury as a class A misdemeanor. Is that correct?
Yes, sir.
Did you review the court admonishments with your attorney? Did you understand it? And did you sign it in all the appropriate places? And counsel, you're waiving the reading of the indictment?
Yes, Your Honor.
Okay. All right. Did you understand the state is proceeding on the lesser included offense of assault bodily injury as a class A misdemeanor? Range of punishment is up to a $4,000 fine and up to 1 year in the Bexar County Jail. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She does.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Ramos, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
If you're not a U.S. citizen, by entering this plea, you will be deported and denied naturalization. Did you understand? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on the lesser included offense of assault. Punishment is to be assessed at 1 year in the Bexar County Jail. There's a $1,000 fine. There's no application for deferred adjudication. State recommends community supervision. This is running concurrent with 2025 CC 012720. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No.
Then outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be 200 hours of community service restitution hours, a TAP evaluation, no contact with the complainant, anger management, and parenting classes. Did you understand that those are recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charge, how do you plead? Guilty, to the lesser included offense, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor, plead for State's Exhibit 1 and all attachments.
No objection, Your Honor.
Did you review the waiver and stipulations of testimony with your attorney? Did you understand it? Did you sign it in all the appropriate places? It's this document.
Yes,
Did you review that with your attorney?
I did.
Right. Did you understand it and sign it in all the appropriate places? Okay. Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you want to say on behalf of your client?
Your Honor, Ms. Ramos is remorseful for what happened. Although the report says that she threw the keys, she actually handed it does say that in the report, she did hand it to the manager, the pilot at gas station. The keys were returned to the CW. She's eager to start probation. She's been on a GPS monitor for a significant length of time. And we ask that you follow the plea bargaining agreement. She does have a child in the ICU at Children's Hospital Methodist. She will have to go through some training with the nurse. The nurse will have to train her how to care for the child. There's going to be some medical expenses she has, so we're going to hope that you could probate part of the fine or all the fine. And since we weren't able to do this morning, the state had to contact the CW to approve this offer. She did go across the street on a monitor to go to Subway. She was hungry. If there's a violation, I just want to let the court know that she did leave the courthouse, but it's just across the street. But we're hoping that you would follow the recommendation and probate the fine. And the community service, 200 hours is significant for 2 years. We're hoping that you can give her some partial credit when she finishes her parenting classes.
So, are you still married to your husband?
Maxwell?
Mm-hmm.
We still, I guess we're co-parenting.
So are y'all still together?
He was just here.
He
just stepped out.
All right. So this is what I don't understand, and help explain this to me. You're in the relationship with somebody, right? He's cheating on you. Why is it you don't get upset with the male? People always want to attack the female. That female owes.
Because,
what do you mean it's an assumption? Assumption of what?
because you said that, I just went after the female and that wasn't the case.
No, that's what it says in here.
I understand that's what it says, but
I think she means that she's very upset with him. Like in the police report, may I reference that she's upset with him? And
Well, here's the thing. I don't understand why you would go after the other party in any case, because guess what? That other party owes zero loyalty to you. The only way that other party owes loyalty to you is if they're at your wedding and they're standing next to you and they're promising to be faithful to you. I don't know why people do this. And it goes back to what I said. Whenever you see adults, when I say adults, I mean people who are not teenagers, and they're kissing in the parking lot as though, oh my gosh, I just can't wait to see you anymore. Those are usually people who are cheating. And what you should have done, instead of not having this charge, you should have just said, you know what? One or two things are going to happen with this situation. Either I'm going to accept that he's cheating on me with this person and discuss it with him when he gets home. And either he's going to admit it or deny it and tell you don't believe your lying eyes. Or either you're going to say, you know what? I'm not going to believe my lying eyes. I'm going to accept that what he's saying is true. Or either you're going to say, you know what? I know he's being dishonest to me. And I'm sorry, I shouldn't say the word lie. My grandmother and my mom thinks that's a curse word, so either you're going to believe his untruth or not, or either he's going to say, yes, I did it and I'm sorry. Either you're going to forgive him. But as far as damaging people's property, destroying people's cars, hitting people, or anything of that nature, it shouldn't even come to that. If it gets to the point where you want to be violent with your spouse or boyfriend or whoever it may be for cheating on you, you need to leave. If you're going to try to confront the person he's cheating with, you need to leave, because that person you're confronting with, number one, they may not know that that person is in a relationship. Number two, they may not care. Sometimes people don't care if somebody has a ring on their finger or not. They're just enjoying the fact that their relationship with the person who's maybe supposedly in a committed relationship or married, their whole thing is like, I don't care, because guess what? I'm constantly in a honeymoon phase. I don't have to do their laundry. I don't have to prepare their meals. The money that he is sharing with his wife, he spends it on me. He buys me clothes. He buys me jewelry. He takes me out to dinners. And you need to make a decision on whether or not you still want to stay in that relationship. And if you would have decided that at that time and just said, you know what? I'm going to take a photo of this. So when he asks me if I'm going to believe him or my eyes, I can say, here's the photo and just move on. Now you're here with this case because he was unfaithful. And maybe this female is still with him or not, who knows?
I'm pretty certain he wasn't honest with Ms. Lopez.
So he hasn't been honest with either of y'all. And maybe if you and Miss Lopez would have had a conversation, she probably would have said, what? I didn't know. I'm so sorry. And left it alone. Instead, you're holding the bag. You're holding the bag for a criminal case that you're going to be on probation for. And your life is no longer your own because you're on government paper. Is this her first offense?
Your Honor, there was a misdemeanor out of this also, but aside from that, I don't believe she has any prior criminal history. She's never been in trouble before. And
In the CC case, what is that about?
resisting arrest, and that was pled just at 2:00 p.m. this afternoon.
All right, and is that related to this case at any way, or is that something separate?
Because it wasn't arrested at the scene, it was when she was arrested for this.
All right. Are you employed?
She's unemployed and she's been on a monitor, so she hasn't been able to work.
Okay. How far did you go in school?
I have some college, and I have like some certifications, pharmacy tech certification. I was doing home care.
Okay, what I can tell you, people who are on probation in my court, I don't allow them to do home health care provider or work with minors. All right.
I do have 3 children. I've purchased about minors.
You're not allowed to be a babysitter. You're not allowed to work at a daycare with your own children. You're allowed to be with your own children. All right, the court is going to find you guilty. The court is going to run this concurrent with 2025 CC 012720. There's to be no contact with Ms. Lopez. 1 year in the Bexar County Jail, suspended and probated for 2 years. Regular reporting by Zoom or in person. Regular random UAs. There's a $1,000 fine that will be probated. Proof of employment within 60 days. There's to be no employment as a home health care provider or with minors. Is there any restitution to Ms. Lopez?
I don't believe so, Your Honor. State.
No restitution, Your Honor. We have spoken with you.
All right, there's to be 200 hours of community service restitution. I'm going to require parenting classes. Once that's completed, 100 hours redeemed satisfied. The other 100 hours probation, she needs more than just anger management. Is there anything else? A step up from anger management?
The hostility that I can't talk right now.
All right, the hostility course. And once that's completed, the remaining hours will be deemed satisfied. Field visits 1 time per month for 6 months. There's to be regular reporting, as I stated, by Zoom or in person. Since you have the child who's in the hospital, probation, see if she's allowed to do that by Zoom. And probation, is there anything else that's needed?
Okay.
Anything else you need from the court to be successful?
Okay.
Yes.
My oldest child has he's disabled and has more than one disability that requires me to physically be there with him with specific doctors on a scheduled time. This is weekly since I've been on monitor. A year later after the incident, I have had to modify my son's doctor's appointment via Zoom. And it's not sufficient enough for him. He's not getting the quality of care that he needs because I'm unable to take him physically to his appointments. And
State, do you want to remove GPS or no?
No objection, Judge. Just She advised by the no contact order with the individual that she's.
All right, if you end up having contact with her, a motion to revoke is going to be filed. Do you understand?
Yes, sir.
And do you understand what a motion to revoke means? All right, there'll be an agreed removal of the GPS. Is there anything else? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
All right, we can go off the record. Here's the thing. I understand when matters of the heart are involved, sometimes people are not able to go through step by step. They just react on feelings. But you don't ever want to put yourself in jeopardy because somebody's cheating on you or something else has happened. Because now, guess what? You have this conviction. And because you have this conviction for this, and because you had this case, then you picked up another case that's a misdemeanor. And if you would have just taken deep breaths and said, I'm going to go back home, I'm just going to wait for him to come home and deal with it then, you wouldn't even be here. All right?
Yes, sir.
All right. In this court, to be successful on probation, communication is key. If you have an issue, let your officer know about it. If you feel they're not addressing it, you can always come back to the court. Do you understand? All right. Good luck to you.
Your Honor,
Thank you.
with the court's permission, if she does need to go to the Methodist Hospital, get somewhere, I know the GPS may take 3 days to come off and it's the weekend. Does she have permission to go to the hospital to see her kid?
Yes, but it shouldn't take them long to take that off. Don't you just report to the location they're going to put in the system that it should be removed? She goes there and they remove it.
I can go there now.
And they usually, my
Yeah.
experience, they usually say that they haven't got a court order yet, so it's not.
They're going to give you the court hours. And let me ask you this. Is there any way you can give her a copy of the court order?
And if I direct go straight to the queue for a jail.
All right. Can you send it by directive and then give her a copy of the directive? There you go. All right. Thank you.
I mentioned that because we also had a motion to modify bond on file, but we don't have to do that anymore because we worked this out.
All right. Thank you. Good luck to you. All right. Willie Phillips. Are there any applications?
For deferred adjudication now.
All right, the court is calling 2025 CR 012782, State versus Willie Phillips. Could I have parties announced?
Judith Wemmert for Mr. Phillips.
And are you Mr. Phillips? Counsel, have you received all discovery? Did you review it with your client?
Yes, ma'am.
Court will find that the state is in compliance with discovery. Mr. Phillips, did you review the application for deferred adjudication with your attorney? Did you understand it? Counsel, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
And just one second. I'm looking at the court admonishments because this is a third degree and I see the court admonishments for the state jail.
Yes, Judge, so we're not proceeding on the indictment as charged, we are proceeding on the lesser included possession of controlled substance, PG1 less than a gram.
Okay, that explains it. I was like, huh. No problem. So let's go back then. Mr. Phillips, did you review the true bill of indictment with your attorney? And did you understand it? And do you waive the indictment?
Yes, ma'am, we do.
And state, are you proceeding on the indictment as presented?
No, Judge, we are proceeding on the lesser included possession of controlled substance, PG1 less than a gram.
Any objection?
No, ma'am.
All right, Mr. Phillips, did you review the court admonishments with your attorney? Did you understand it and sign it out in all the appropriate places? All right, the state is proceeding on the lesser included offense of possession less than a gram, penalty group 1. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, The court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Counsel, has your client been able to provide you with any defenses?
Yes, ma'am, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Mr. Phillips, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? All right, if you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry into the United States. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, the state is proceeding on the lesser included offense of possession of a controlled substance, penalty group 1, less than 1 gram. There's a $1,000 fine and the state recommends deferred adjudication. Did you understand that to be your plea? Defense?
Yes, ma'am.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, ma'am.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 2 years. There be a TAP evaluation, 120 hours of community service restitution, regular random UAs, and the DOEP course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor. Plead up for State's Exhibit 1 and all.
No objection from the defense.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, ma'am.
Anything you wish to say on behalf of your client?
No, Judge, we'd ask that the court follow the plea bargain. And it's my recollection that the court perhaps has an alternative to all the community service hours. Mr. Phillips might be interested in that.
All right, Mr. Phillips, do you have any type of mental health issues? Have you ever been diagnosed with anything? Have you ever been on any type of mental health medication at all?
I believe so in 2008.
I'm sorry?
I believe so when I was, I think it was, forgot the name of the medication. It was like depression.
All right. And how old were you at the time when you were given that? Okay. So is there a reason why, what was going on in your life at that time? And do you have any family support? And what family member is that? So how often have you been using?
Drugs.
Mm-hmm.
Well, recently none at all because I've been hearing, but
Yeah.
on occasion, it's not nothing that I absolutely need. It's just some of recreational, I guess. It's not something I go looking for. If I don't have it, I don't have it. It's a great activity.
Well, this night you were looking for it, right?
No, I was not.
Because they're saying that you came from behind this hotel.
Was looking in. I mean, like the way I was making a living sort of is refurbishing items that I would find in photography and dollar stores, warehouses, doorway, goods that aren't really broken, they're just dysfunctional for whatever reason. Didn't when they throw it away. Laptops, all kinds of things I find, bikes.
But what time of day was this?
About 3:40 morning.
See, who's out looking at 3 a.m. in the morning?
There's other people that who looks for people to do it. But yes, no. To be bothered, he didn't bother. That kind of thing, like work. Okay. And customers' ways and interfering with traffic and stuff. Park lots were mostly. That night, it should be. There was a construction. That's right now.
Do you have any children? What are their ages?
25.
Do you have any grandchildren?
2 years.
And what are their ages? Have you had any contact with your children recently? Have you lost contact with them? And when I say lost contact, I mean that you don't communicate with them on a regular basis.
Yes.
And why is that?
Shoot, I had in the past that I didn't want to interfere with their mother's relationship. So the best thing I felt for my well-being, let her leave her part, issues that can come about from trying to basically be in someone else's life. They're no longer wanting that to be. I can take good advice as you did that young lady so before. We can discuss it or leave it alone. Past experiences that got me. Didn't get it before until I back up. Yeah.
All
My
right.
best interest, I was the best advice.
And where you're going to be staying, are there any minors in that home? Oh, I don't need to know the address. I just need to make sure that there are no minors residing in that home. All right, I'm going to give you your conditions. Just remember, these conditions can change once you've proven certain things to the court. All right. The court is going to sentence you to 2 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, a TAP evaluation out of custody, follow TAP recommendations, with the exception if they want inpatient treatment, we will begin with outpatient treatment. Field visits 1 time per month until further notice. There's a $1,000 fine. It will be probated. 120 hours of community service restitution. You can either do those community service hours or you can do sober support meetings. For every sober support meeting you complete, an hour will be deducted from your community service restitution. Proof of employment within 45 days. No employment as a home health care provider or with minors. No residing in households with minors, and no unsupervised contact with minors. Probation, is there anything else? Is there anything else you need from the court in order to be successful? All right, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. In this court, to be successful in probation, communication is key. Whatever you do, always make sure you report. If there's an issue, discuss it with your probation officer. If you feel they're not addressing it, you can always come back to court. You understand? All right, thank you. All right, who is Stacy Smith's attorney? And what page? On page 2 o'clock. All right.
Hi, Your Honor, Judge.
Southwest.
She was done.
Just simple people to burn-ins.
All right, so, once you've been found incompetent, there's nothing that the court can do until they determine that you regain competency.
Yes, because I did mail in a motion recently to fire my lawyer and to
Okay.
replace my court-appointed lawyer. He has not communicated with me at all, and this
Okay, let me-
incompetence issue has thrown me for a loop, and it's
Mhm.
really freaking me out, and it's just not true.
Okay, so this is what we're gonna do. We're gonna call you back for another date. All right, and so I'm gonna talk with the magistrate's court and see what's the best date to bring you back, all right? So the deputy is gonna take you back now, and at the next setting, we'll make sure your attorney's here, okay?
Okay, and I can't do anything about this because he's never communicated with me at all.
I'm gonna make sure that happens, okay?
Letters, and I know I'm not incompetent, and this is very frightening, and I don't know the repercussions of
Okay,
it.
so I'm gonna make sure that that's taken care of. We're gonna bring you back, okay? All right, have a good day.
Thank you.
You're welcome. All right, we will be back on what, December 1st?